released on bail. But unfortunately, ADJ has rejected my bail and I have filed an IA against that.
So rejected bail, then remedy somewhere.
But Lordship will reflect some observation
I
on
just
that.
gave observation to help you out.
And the bail also. I have also filed on bail.
That's right. Bail is now rejected, then you go somewhere else to do that.
I filed on bail before this honorable court. High Court.
High Court will take up the bail matter.
Bail court will take.
But observation will be there, it will be.
Okay, you give it. I think now the assignment is going to change and bail matter will also come to me. Some bail matter will come to me, then I'll see.
Challenging order of cognizance.
Yes.
Are there arguments in that coming?
Pardon to mention, my lord, item 56, there is no state, my lord. Pray for next week, my lord. Conducting
Is there
counsel.
the opposite party is there?
I am for the petitioner, my lord. State is the opposite party, my lord.
State, okay. Jen, what is that?
56, my lord.
56, okay. Very good.
Obliged, my lord.
Senior advocate Mr. Ashok Mahato, item number 90.
90?
Item 90.
One
No
nine.
stay order.
Adjournment.
Adjournment.
There is a say
No stay.
19 adjourn. Note it down. We'll adjourn it, but
Yes,
if anybody will come and
I have a mention, Lord.
don't decide the date.
I think
Because
requested.
look at the assignments, the board. We have to adjust, otherwise everything will be,
Adjourners.
very difficult to handle. Unless you follow a system, then there will be a uncontrolled kind of
Senior
situation.
advocate has requested me.
I will see. If 7th is possible, give it. Huh? It is curious. Huh? There is a specific request by senior. So
Senior
that,
advocate has requested.
note कर देता है 7th ही पर ही
7th is well.
Yes. Thank you.
Item number 36 can be taken up to
Hmm?
Item number 36.
You want to withdraw?
No,
2 weeks.
adjournment.
Okay. After notice or
It's a press matter.
press matter?
Yes.
Lord,
One.
with your lordship's kind approval,
Hmm.
I have a
Yes.
mention.
Yes.
One CRLMC 472 of 2024.
Yes.
Here, Lord, the allegation of deficiency in service of a customer of Toyota car.
Hmm.
But affair has been lodged implicating all the directors.
Take the number.
All the directors as the accused.
Give a memo. We'll see. We'll get it.
I will send CRLMC 472 of 24. Well, maybe list.
Okay. We'll see. We'll get it. Okay. Yes.
May I please your lordship, my lord?
Hmm.
Here is a case, my lord. This case notice has not been issued, my lord, to the opposite party. Because, my lord, on order dated 11/12/2023,
Hmm.
my lord, please to direct me to produce the 161 statement of the airport PS case number 227 of 2023, and in interim my IA directed no coercive action. Then, my lord, posted on, my lord, 9/1/2020.
On December 2023, you have taken no course action.
No coercive action.
Thereafter, you are not taking any course action yourself.
No, yourself, my lord. Then, my lord, date 9/1/2024, I took time because I have to produce the 161 statement, my lord, in respect of their case.
Now what happened?
What happened last occasion, my lord directed to me take steps for the OP number 2, but till yet, my lord, notice has not been issued, my lord.
It is written that it is made clear that if the steps are not taken to serve the opposite party number 2, the interim order passed by this court on such and such day will stand automatically vacant.
But till yet, no notice to the opposite party by court.
Why? It's a court's problem. His problem.
Notice issue here.
Huh? That he is not responsible. It is your problem.
My lord, may issue notice to the opposite party. I will issue that.
So then again we have to issue. It is informed that the notice could not be inadvertently notice could not be issued by the office by the registry of this court. Therefore, press notice is to be served on opposite party number 2. Then necessary steps may be taken by the petitioner to serve opposite party number 2. or entry order to continue.
By registry post with AD, my lord, directed to,
Raise the post and AD,
my lord, directed to issue notice to the OP number 2.
open number.
Issue notice to the OP.
And entry order continue.
Continue.
By luck. By your luck. Otherwise, there was a clear, it will be automatically vacated.
Notice,
But now office may take what to do. Okay, anyway.
notice
Entry
filed by-
order to continue.
continue by within
Wait,
three,
wait,
within 3 weeks
3 weeks.
working day. Within 3 working days.
Within 3 working days.
Requisite to be
If
filed.
you get it, be careful if any problem. Ask. Don't write whatever you.
I filed the requisite within 3 working
Okay.
days. Okay.
Yes. Password. Yes. O- 1 minute, sir. Item 2 withdraw. Item 2 withdraw. Memo is there already. Memo file that's taken on record. Yes, sir.
That annexure 3 is the
6/2/2016 order.
order of NBW. I have challenged, but he was not released on, he has never granted bail earlier. Well, earlier he had approached the Hon'Ble court in a anticipatory bail application and that was not entertained.
And you didn't go, then NBW.
But here the only circumstance is that, well,
But NBW is issued long back in 2016.
During the course of investigation, my lord. The IO, prayer of the IO.
but charge sheet has been submitted against
Look,
3 appeal persons.
the petitioner had challenged the order dated 6/2/2016, whereby the court below had issued NBW against him on the application of the IO. Full stop. The anticipatory bail application of the petitioner was rejected, and he did not cooperate with the investigation. Therefore, the IO moved an application for issuance of NBW. Accordingly, NBW is issued against the petitioner.
In
On
fact,
this-
my lord,
Hmm.
we have to solve the copy on the OPID council is there.
I will just
Archer.
state, let him go and appear.
Yes.
On his section, the counsel for the petitioners submits that his client would be appearing before the court on or before 7th of March 2024 and seek remedy available to him under law. Taking into consideration the aforementioned fact and submission at the bar, the execution of order dated 6/2/2016 is kept in abeyance till 7th March 2024. So as to enable the petitioner to avail surrender before the court and avail remedy under law.
Parity maybe.
No, that I had not right.
Yeah, on the-
2016, no. You should have gone 2016, you should have, try to, and you have to pay some cost also. You have to pay some cost.
Even if my lord in the charge sheet, my lord,
Huh.
he has not charge sheeted, my lord.
But he has not been charged.
Whatever, then you will
3%.
be released on bail immediately. And this order is subject to the petitioner paying a cost of rupees 1,000 to loan.
But a 7 ର ଆଉ ଟିକେ ଖାଲି
7 ନହେଲେ ଆପଣ ଇଏ କରନ୍ତୁ, ଏତେ ଦିନ ତ କଲେ 2016 ରୁ
ତ କି 15 ତାରିଖ କରୁଛି।
15 କରିଦିଅନ୍ତୁ, 7 ଠିକ ଅଛି। At least you go and surrender and get the bail. If charge sheet is not filed, you are out.
Charge sheet, keeping investigation open against.
Other than
ଖାଲି parity ଯଦି ଟିକେ
No. 2000 ଆପଣ ଯଦି ଏବେ ଜଲ୍ଦି ଆସିଥାନ୍ତେ ହେଇଥାନ୍ତା, 2016 ରୁ ବସିଥିଲେ ପାର୍ଟି ମାଗିଲେନି, ଏବେ ଆସି ପାର୍ଟି
others have been released on bail.
that would be a ground obviously.
Item 4, may I please allow?
Yes.
It's a Belgium matter, my lord.
Yes.
NBW issued on 30/11/2023, my lord.
Okay. Bail.
Bail on dated 25/10/2018, my lord.
NBW is on
30/11/2023.
22,
23, my lord.
23, 500.
Oblige.
Undertaking to repeat. When there is a question, very good question, write out so is what, where the petition.
Some 5 Belgium matter.
Yes.
The order is on 23 December 2023. 317 petition was filed and 10 petition is rejected.
Verification submits that the petitioner moved an application under section 317 CRPC. However, the same application was rejected by the court below, and NBW has been issued against him on 23/12/2023. ठीक है? यहाँ पर लिख दो undertaken 500.
6 ମାସ 6 ମାସ ବି ହେଇଛି। 2 ମାସ ହେଇଛି।
2023 ବେଲେ 5 ତାକୁ ମାସ ଦେଖିବ ନା କଣ?
Belgium matter, my lord. NBW issued on 13/7/2023. 370 application has been rejected.
Same 37 application rejected जो पहले डाक्यूमेंट ना ये जिन सबको डेट टा चेंज कर दो। डेट कोटा एटा होची 6 ला डेट होची 13/7/2023 NBW same जिन सब 317 application was moved rejected in the first order for the 500.
7 also, my lord. This is Belgium matter order dated 3/11/2023, my lord. 1 and 2 are court bill. I can see the order dated.
No, tell me the dates. I don't want to see that.
Bill legal, my lord. 1 and 2 gala uchi 17/5 and 24/3 respectively, and others 41 comply, my lord. Others
How many of you are there?
5
You are
number
the
of
only one.
accused. 6 number of accused, my lord.
No. Which is the item?
Aya
7.
7.
7.
6 number of accused person.
6.
Aya
Then what happened?
1 and 2 gale again 17/5 and 24/3
1 and 2, 17/5 to 24.
respectively. Aya
And respectively, and the other
other order 41 comply. Well, can see the order
Erase it.
Aye. Sorry.
che ulta likh do puni
sorry.
application logo.
Sorry, my lord.
Tell the date.
17/5 and 24/3. हाँ 17/5 22 and 24/3 23.
कहबे ना
Aye.
year छाड़ देबे. And in so far as the other petitioners are concerned,
41 comply.
41 notice was served on them. However, however, due to non-presence in the court on 3/11/2023, NBW has been issued. तापर से इसको करे 500 नहीं आपण के 6 जण अछन तो
6 जण आज्ञा गरीब लोकड़ा
गरीब लोक 6 जण ले
सेथरे स्त्री लोकड़ा गुडे अछन आज्ञा स्त्री लोक गुडे
ओके 2000 समस्त मिछि 2000 व्हाट इज
आई
ओके
Please, your lordship. My lord, 3 petitioners are there. 1 and 2 were released. 1 and 2 were released on 31/7/2013, and petition number 3 was released on 18/9/2013.
and then 2
1 and 2 are on 31/7/2013, and NBW was issued on 28/8/2023.
28
August 2023.
23 okay
My
500 each
317 application was allowed, but NBW was
500
Mine.
500 each
no.
so 1000 3 जण अछन तो 1
Mine.
yes
May I please? And NBW was issued 17/12/2018. Bail order 21/9/2013.
18
17/12/2018.
केते जण अछन आपण
जने
1000
2013 order.
1000 bail jump oh कितना number item
9.
you have to see the file also the file you will get it but the in so far as the grant of bail you may not get therefore I'm asking but yes tally the NBW was issued on 17/12/2018 yes 29/9
21/9/2013.
29 yes
My lord, 130 Act, my lord, NBW dated 13/1/2020, my lord, at page 9, my lord. Say both parties are present and files hajra, accused is absent on repeated calls. is hence issue NBW against the accused
This
fixing.
is accused in the ICC case number 3775 of 2018 under section 138 NIA. Due to his absence in the court on 13/1/2020. 2020.
Yes, my lord.
NBW has been issued. He undertakes to appear so and so 1000.
Right.
Are you complaint case? Are you to complaint case? Once.
May I plead your lordship?
Yes.
Lordship, this is the application where I have challenged the rejection of my application under section 457 CRPC regarding release of my vehicle,
Yes.
which last two occasions, your lordship specifically directed the state council to take instruction whether any confiscation
Yes.
proceeding has been initiated or not.
Yes.
Though charge sheet submitted, my lord,
Huh?
the IO, my lord, even in letter on perusal record, no such proceeding to confiscation the property of the aforesaid accused Sushant Pradhan has been initiated at a Hon'Ble PS. PS
Your lordship, though there is a
Okay. The matter was taken up for hearing on 2/2/2024 by this court, and the following order was passed. Order. Pursuant to the aforementioned order, Mr. Rogada has obtained instruction and the same is taken on record.
Charge sheet already submitted, but
As per the instruction,
last line.
the instruction furnished by IIC Hon'Ble PS, though the charge sheet has been filed.
charge sheet I have already annexed, your lordship.
Though charge sheet has been filed in the present case, no proceeding under proceedings for confiscating the no proceeding for confiscating the property in subject has been initiated against the petitioner. Therefore, the impugn order dated 22/2/2023 is liable to be set aside, and the liable to be set aside, and the application under 457 CRPC moved by the petitioner deserves to be allowed. Accordingly, where is that order? 22/2/2023.
That is annexure 7 starts from page 35, your lordship.
Accordingly,
annexure
what is that article you wanted?
Your lordship, that's a Tata pickup van, your lordship.
Accordingly, the Tata pickup vehicle number so is directed to be let us the trial court pass appropriate order directing release of the Tata pickup van bearing number bearing number OD days 19 days G days 9643 with appropriate conditions as making it proper.
Sorry, your lordship, that is Bolero pickup instead of Tata. That is
Bolero pickup.
That is annexure 1 registration.
Go and ask, he will impose condition and release. Okay.
Your lordship, I have relying upon a judgment.
What judgment?
All the condition has been mentioned, your lordship.
You go and that court will decide.
Magistrate order
and annexure 6 and 7.
And accordingly, the order passed by the which item was the
annexure 6 and 7.
No, which was the item? 11. Accordingly, the order dated magistrate order is
16/12/2022, your lordship.
16/12/2023.
22.
2012 लिखे हो तुम. Passed by SDJM Athmalik in CM case number 151/2022 is also satisfied.
May I please, your lords? My lord, there is two applications preferred by the present petitioner. The first one, last occasion, while your lordships are hearing the first application, that is for a permission for no objection to go abroad. While hearing that case, your lordships will plead
First
to,
one,
my lord.
3102.
My lord, your lordships I plead to, as because there is a 492 case was pending before the present petitioner. Your lordship said that if that case will be heard first, then while hearing the second one, as there is a settlement between the parties, and my lord, kindly peruse page.
No, what exactly you want? Let us see.
Madam, there are two cases, my lord.
Passing
One
a
case, my lord, they filed the petition for renewal of their passport, my lord.
Huh?
So, your lordship on that day taken a view that if the case will be quashed, my lord, then not necessary. Since matter has, my lord, the another case, CLMC
Okay, let us see
3172.
the order dated 8/1/2024.
My lord.
The Constitution of the petition submits that this petition arises out of a matrimonial dispute. The parties to the dispute have settled amicably. Acha, you have settled amicably.
My lord.
Where are the parties?
My lord, for that reason, my lord, your lordship asked me
Hmm.
to take instruction. I have even taken instruction from the IAS, my lord. Notice could not be served due to the applicant to reside at Bangalore, but in fact, his family member stated that matter has been compromised. But in fact, my lord, the notice could not
And the
be,
notice could not
and
be served on the.
and the case pending for appearance of the accused.
So what to do now?
Lordship,
Madam, matter has already been settled. 20 lakh last occasion your lordship has taken a view.
say Bangalore address the
Parties to
better.
settle the amicably and the memorandum of settlement dated from.
Your lordship may allow the first case renewal.
Affidavit of the parties has been placed on the court. On the basis therefore, settlement, the parties have applied for divorce and certain be of the marriage and judge matrimony and also agreed to grant mutual divorce. And the petitioners have also been paid around money 20 lakhs. And in the factions, the notice the officer intimated ability could not be served now, huh? The matter was
The fact remains, my lord.
okay. The matter was taken up in this first matter. Huh?
First matter.
The number is 3102. Huh? 3102. The matter was taken up the no 3102. 3102. Right? The matter the connected matter being CRLMC 3172 of 2019 was listed before this court. On 8/1/2020. The following order was passed. Right. Pursuant to the aforementioned direction, Mr. Ragada obtained written instruction from IIT Hon'Ble. So the instruction is taken on the court. As per the written instruction, the IIC Hon'Ble has stated that since the complainant is staying in Bangalore, the notice could not be served. Notice could not be served. However, next one. From the record, it is from the record. It would be it is germinating from the record that the parties have indeed settled their dispute, and they have also parted away by seeking the dissolution of their marriage by mutual consent. The permanent alimony has also been paid by the petitioner to the opposite party number 2. A memorandum of settlement dated 30th August 2019 has also been placed on record. Mr. Ragada submits that since this dispute is essentially arising out of a matrimonial dispute, and the parties have settled their dispute, and documents in this regard has already been placed on record. There is no legal infirmity in what's in the FI, watching the FI. Taking into consideration the aforementioned fraction.
But,
Yes.
my lord, the two things are there, my lord. The notice not sufficient, one thing, my lord. Second thing, my lord, it is a case, my lord, not assigned to university, my lord, the 19 matter, university.
Which one?
In which case, your passing order, my lord, that is.
No, the first order.
My
No,
lord,
I'm passing in that, in the first matter I am passing.
first matter, then, my lord,
First matter only I am passing.
3172 to 19, my lord,
Yes,
that
yes.
is passing, my lord.
310223, I am passing the order. I am checking in the connected matter, I passed the order earlier. In this matter, they have not placed that E. I'll correct it. And because 3102, if you see, 3102, and the order dated 8/1/2020 is not placed. Just see, should give me that file. First one. Where is the order? That's the reason I have dictated this. This is how you people do, what to do.
But in fact, order passed in 3172, my lord, 19. But this present case, my lord,
Second matter, just see.
second matter order pass it. Yes, sir.
That's the order I in fact passed in the first order. And you put it in the second. This is not in our sense.
No.
Okay, how will you please see?
And for that, I am perfectly remember, my lord, your RC wanted to see whether the matter comprises, for that is the instruction sought for.
That's right, instruction I sought in this matter, first matter, but the proceeding is recorded there. This is how you people do it. Who has done it? Let's see. Second, two, correct. Write down in the second, first write down. First, this is the first matter. Second matter, write down. Second matter. Inadvertently, you show me this both the files. Inadvertently, the proceeding recorded in the connected matter, namely in CRLMC number 3102/2023, 2123 on 8/1/2024 has been placed on record in the present matter. In the present matter. Present matter. In the present matter. Present matter. Present matter. Since the present matter is not assigned to this court, we inadvertently the order dated 8/1/2024 inadvertently placed on the record of this in the record of this file may be taken off the record and place it place it in the connected matter. Place it in the connected. Take out that proceeding, write this proceeding and the earlier proceeding 8/1/2024, place it in the other file. In this file, there is no one. You bring it.
Simply adjourn, my lord, the present case.
See,
And both the case dispose of?
no, the second matter I can't dispose of.
My lord.
Leave the matter.
Before the
second matter. Leave the matter before appropriate matter.
3172.
Subject to the approval of the Honorable Chief Justice.
On the first matter, the
First matter disposal was.
the order of the lower court person.
The first matter, the
renewal of the
entire proceeding is cost.
Well, they have filed for renewal of the license.
The first matter.
My lord. For that reason, my lord. For renewal, my lord.
Right down. First matter. First matter. You people are unnecessarily creating problem. And our office is also
on their priority
adding to my
lord,
problem.
Saitar
First of all, you people are creating problem. and these people further adding that problem.
My lord,
And I have to spend the time only setting the record correct.
more different prayer of office jodi dela eta more prayer.
I don't know, this is the so casually with the High Court, the staff is also like that, and you people are also filing like that. You are wasting time in this. Last sentence you write down. The 3102. Taking into consideration the aforementioned facts and circumstances, the petition is allowed, and the order dated 22/2/2023 passed by legislative SC Hon'Ble in GR case number 4 so and so 15 is Sarasa. 2015 arising out of Hon'Ble PH case number 90 of 2015 is Sarasa. Baki the other crossing you can go and do it. I'll correct it.
My lord, I may be permitted to.
I directed to list it before appropriate.
No, my lord, in the past case, my lord, that order was.
I have set aside that order.
Or no.
You go and ask there.
I have set aside that. You people are you are not sure about what you are asking. You are not sure about what kind of petition you are filing. There is no annexures. And to what extent the court will help you, tell me? This is no way of conducting cases in High Court level.
For that you also wanted to know the exact.
And I want to help you to find out some solution, and you create further problem for your client. Anyway, okay. Yes.
Please, your lordship.
Will you not see whether it is in our assignment or not? You connected my thing there. It is my order where I asked in the assignment. You don't select the proceedings there. We are placing the proceedings in a matter of so casual. Release your job. Yes.
My lords, here the petitioners are aggrieved by the order at Annexure 1, taking cognizance against them, my lords.
Yes.
Petitioners are parents-in-law and husband. Cognizance has been taken against them on sections 498A, 294, 506, 323 by 34 IPC and 4 of the DPI.
Who are they? They are the
Parents and husband.
husband is Sibo Sankar Das is the husband.
My lord, husband.
And parents are Arjun Das and
My
Malati Das.
lord. My lord.
Okay.
Your lordship may look at page 16 of the brief.
16?
Of the
16?
brief. Yes.
Okay.
That is the FIR.
Yes.
In the second line, she says, ମୋ ବିବାହ 2/5/19 ତାରିଖରେ ଶିବ ଶଙ୍କର ଦାସ ପିତା ଅର୍ଜୁନ ଦାସ ମହେନ୍ଦ୍ରଗଡ଼ ଥାନା ଆର୍ ଉଦୟଗିରି ଜିଲ୍ଲା ଗଜପତିଙ୍କ ସହିତ ହୋଇଥିଲା। ମୋ ବିବାହର 2 ଦିନ ପରଠାରୁ ମୋ ସ୍ୱାମୀ ଶାଶୁ ଶ୍ୱଶୁର ଯୌତୁକ ଅନ୍ୟାନ୍ୟ ବାବଦରେ ଅନେକ ପାଟିତୁଣ୍ଡ କଲେ। 2 ଲକ୍ଷ ଟଙ୍କା ନଗଦ ନ ଆଣିଲେ ମୋ ସହ କୌଣସି ସମ୍ପର୍କ ରଖିବୁ ନାହିଁ ବୋଲି କହି ନିର୍ଯାତନା ଦେଲେ। Now your lordship may see after 4 lines thereafter. She writes, ମୋ ସ୍ୱାମୀ 15/2/19 ନାସିକ ଚାକିରି ପାଇଁ ଗଲା ପରେ ମୁଁ ପିନ୍ଧିଥିବା ସୁନା ଆମ ଘରେ ଦେଇଥିବା ସୁନା ସବୁ ଜୋର କରି ଶାଶୁ ନେଇଗଲେ। Lords, if the marriage was on 2/5/19, how could this happen on 15/2/19, my lords? Prior to the marriage.
Maybe some typo, maybe it may be 15/5 instead of You show me 161 statement, there may be a typo.
I don't have those copies. See, that is written in the formal FIR also the same
I
thing.
understand it, but it must be typo.
No, my lord.
It should be 15/5/2019.
Lord, same thing, my lords. Will look at page 15 of the brief. First information contents.
Yes.
On 9/4/21 at 11 AM, complainant so and so appeared at PS, presented.
I know the same thing is written. I could see that. I could see that.
Same thing is
but-
there in the charge sheet also.
But where is 161 statement of the girl?
My lords, I have not received copies.
I'll simply issue notice. Let us see the
Yeah,
matrimonial.
my lords. Yes, your
Ah,
lordship may issue notice.
Because I am averse to the position that if the mother-in-law, father-in-law should not be prosecuted in these kind of
My-
cases. And sometimes the entire family.
Right.
So I'll simply issue notice. Let us see.
Yes, yes.
Issue
Your
notice to
lordship may
opposite
issue
party.
notice.
Opposite party number 2. So as to explore, shall I write? So as to explore the possibility of settlement.
Yes, your lordship can do so.
Yes. Issue notice to the opposite party number 2, or written able we can so and so. Mr. Ragada accept notice for state. The notice is issued to opposite party number 2 to explore the possibility of a settlement in the present matter. Let them come. We'll send to mediation and try to finish it up. Okay.
And let Mr. Ragada obtain the case records also.
Case diary.
And notice in the IA also.
Notice on the IO. Notice on IO also, and fix it in the March second week or third week, whatever.
Third week of March.
Third week, yes. Next.
Item 14.
Please, your lordship.
Yes.
My lord, all the offences are tribal by my states. There was a law of relation in between the petitioner and opposite party number 2.
So what do you want?
Settlement, my lord. Already settled.
I've already filed that.
But where are they?
But that today they have not come. Lords may keep it. First March they will come.
1st March.
1st March.
Adjourn to 1st March.
It is cybercrime.
1st March, देखिए.
No, the offense is cybercrime.
Yes. I
Interstate cybercrime offense.
Interstate.
66 and 67 and 66.
No, what is the allegation?
It is not permissible, but it is against the society and the state.
What is the allegation?
But the offense is 294, 419, 420, 506, 66C, 66D, 66E, 67, IT Act. This is the offense, and they have what they have did.
Wait. That judgment, Supreme Court judgment 66 regarding 66, just check it up.
Yes.
Place before you.
Yes.
And
Yes.
come with that.
First March.
There is a judgment of
Yes.
66.
Right.
Check it up. Yes.
Item 15.
My lordship. The petitioner challenges the order dated 15/12/2023, in which that is page 9, my lord. The Honorable Court below has revoked the bail order, my lord. The background of the case is that the present petitioner convicted in a case under
Revoke the bail order.
bail order, my lord.
Bail is cancelled.
Yes, my lord.
Bail cancel, appeal, convicted, appeal filed. Condition was imposed while the bail is going to be granted. Learned Sessions Court granted bail with condition that you have to pay 20% the amount, fine amount, compensation amount as per 130, 143. But he did not deposit in time. Thereafter, the condition was that unless until you deposit, the bail order and the fine amount, stay of fine amount, duration of fine amount shall be
130.
revoked.
Yes,
Yes,
sir.
139. 143.
So then,
Ready to deposit, my lord.
ready to report.
Yes, my lord.
It's very simple.
Simple kata hai udhar.
Subject to the issue notice to the opposite party number 2, opposite party, single opposite party. Orissa Gramin Bank, opposite party. Returnable within 2 weeks. So when you have not moved an application for stay also.
No, my lord.
Sorry, opposite party number 1 you also may kindly mention because 2 is state. Yes.
Opposite party number 2, Mr. Maharaja appears for 2 weeks notice.
Yes.
You are not asking for stay or anything.
No.
No, my lord.
He has not.
You will deposit the amount and release bail.
That there is no application, there is nothing in everything is orally.
Taken up next week, my lord.
Where is the application? You have not filed anything.
May I pray, Lord, may kindly turn to page 10.
Was fine. In a Priya Ranjan Chaturthi. This is something else.
It can all have been second. CRLMC 290. I don't know. 290 type.
So what to do? You have not moved application anything, what to do? Simply notice letter.
Notice करन तो plus dispose of कर दिए भलो के subject to payment of 20% amount. Your lordship may kindly turn to page 10. That will satisfy your lordship.
Yes.
The case record showing that the appellant has, my lord, I am reading 1, 2, 3,
10,
para
10,
3.
1 minute.
Para 3.
10, yes.
Para 3 starts from the case record. The case record shows that the appellant has failed to deposit the 20% of the fine amount as per the order dated 14/9/2023 within the stipulated period of that is 60 days and thereafter another 30 days as per the provision under section 148(3) of the NI Act.
How much time will you take to do
Exactly.
this?
Within a week, madam.
Within a week.
Sir, सेटा करके dispose कर दे
Dispose of. Thank you very much. Write down. The petitioner has challenged the order dated 15/12/2023. Where is that order? 15/12/2023. Whereby 15/12/2023. Where is that?
That is page 9, madam.
Huh?
Page 9.
Page 9. Page 9.
9.
Just below. Computerized compared by just below. 15/12/2023. Page 9.
15/12/2009.
23. Plus you got it. Page 9. Page 9. First date ଅଛି 6/10/2023.
15/12/2009.
Yes.
Which was been prepared and the appeal is dismissed, huh?
Yes. No, his bail application and the relation fine application has been revoked. It was allowed subject to payment of 20%. He failed to deposit. That is why.
Bail order revoked.
So why he is challenging this?
चैलेंज बेल जो बेल ऑर्डर टा दिया हेतला ओ फाइन अमाउंट स्टे हेतला सेटा रिवोक हेगला ना से पेमेंट कर पैलानी इन टाइम रे
where is that revocation part?
That is page 8, my lord, bail order, my lord, 14/9/2023.
No, when that impugn order show me where is the revocation?
Revocation is page 10. That I am reading.
10, which one?
Para 3.
Or this the one, huh?
The case records.
Yes,
that is
towards
whereby the bail granted to the petitioner in the case has been revoked. The learned court below, while in this said order entry he has stated para page 10 para 3 last order. In the case record source.
Bas.
It starts with in the case record source and to Jagat Singhpur in Jagat Singhpur for information last. That paragraph. What's up? Land counsel for the petitioner on instruction submits that his client is ready and willing to deposit 20%. What is the amount? 20%?
60,000, madam.
Huh?
60,000, madam.
60,000.
Out of 3 lakhs.
20%,
60 lakhs.
Of the compensation amount as directed by the court below within a period of 1 week from today. Subject to the petitioner depositing the 20% of the amount as directed by the court of sessions judge Jagat Singhpur in
criminal appeal.
Criminal appeal number
33 of 2023.
Yes.
The order impugn order dated 15/12/2023 is set aside.
Set aside. Yes.
Accordingly, the petition is allowed.
Yes.
Subject to making payment in full.
Yes.
Yes.
16.
May I please, your lordship, may I bring for 1 week after.
Huh?
Bring for 1 week after.
One urgent.
Obligation.
17.
My lord, petitioner challenging the cognizance order dated 10/12/2015 under Annex 3, my lord, punishable offense under section 457, 397, 420.
Okay, what is the case? Why?
My lord, as per FIR, my lord.
Forget about FIR. Charge sheet, you tell me.
My lord, as per FIR, my lord, 395 IPC is registered, my lord, against the
Cog-
unknown person.
Cognizance is taken on the charge sheet.
My
After
lord.
charge sheet, what has come against you? Show me.
My lord, I am not involved in this case, my lord.
You show me, charge sheet is filed, not involved means what? Something must be there against you. That is why charge sheet is filed. Show me the charge sheet allegation. Are you ready with the matter or not?
No, no. Taken up one week after, my lord.
Urgent. Not ready with the matter. Yes.
My lord.
Yes.
Might be the last.
Yes.
And Annex 1 starts from page 8, my lord, that is the FIR law.
So it's a vigilance case. My friend has given the copy to me, and your lordship may kindly direct him to serve the copy to the vigilance.
You give it to Mr. Maharana.
Maharana, yes.
Give it to Maharana and we'll list it with him. List it. Second week.
Second.
Item 20. Write down. In your case, you write down. No? 1 minute.
18.
Write down. Write down. Then concept of the petitioner submit that we would be serving the copy for advance copy of the petition to the council representing the vigilance department. Vigilance department. He may do so. He may do so within 1 week, hence, and list the matter answer.
Okay.
Yes. Item 20.
May I please, Your Lordship?
Yes.
Challenging the FIR as well as praying for passing of the FIR.
Yes.
Under Annex 1. Alleged offense under the 420, 469, 406.
Investigation is still on.
Yes, Your Lordship. And then the newly, the FIR registered on 23rd of January.
Wait till the investigation is.
And Your Lordship, was passing for the
investigation is on. How can
Your
it
Lordship,
pass?
illegal FIR, Your Lordship, is 420 is not at all made out.
That after investigation only will come to know.
Scheme
whether
the
it's made out or not.
Actually, FIR is the investigation.
Now it is very threshold. We don't know whether it will be made out or not. If it is not made out, they will file a closure report.
Even the investigative officer does not know how, whether the case is made out or not. He has to investigate it.
You withdraw with the liberty to approach the approval. Then counsel for the petitioner seeks to withdraw the petition. By way of the present petition, petitioner is seeking passing up of the FIR in CT case number 48 of 2024, registered on 6/1/2024.
Yes.
The investigation is still going on. Next product. Then counsel for the petitioner submits that he would withdraw the petition, reserving his right to approach this court at the appropriate stage.
Yes.
If the cause of action survives. Let me say. Yes. Yes.
I may be certified copy of the FIR may be written. Certified copy of the FIR may be written, ma'am.
He seeks permission of the court for return of the certified copies he has filed along with the petition. The same shall be written. The registry is directed to return the certified copy, keeping replacing by Xerox copy.
Obliged.
Yes.
My lord, item 21 matter has been compromised between the parties. They have come, my lord. Let it come to at 2 p.m. my lord. I will.
22.
Item 22 pass over, my lord.
Every time, why are you asking pass over?
Sir is
I'll
like-
pass over, but you have to argue. Next time. At 2 o'clock, get ready and come. Argue. Yes. 23.
Lordship, item 23, compromise between both the parties, they will come. Matter will taken up at 2 p.m.
2.
Obliged.
Password, my lord, on behalf of Sibo.
Password.
My lord, it is relating to release of that vessel. So far as the MD is concerned, my lord, we obeyed your lordship's directions. We are willing to cooperate as and when it comes up.
That's what he want to make a statement that he will not be
I
arrested.
couldn't appear that day, but we have, in fact,
That's a fair suggestion on their part.
my lord, whenever that comes up, I'll address your lordships on that. But this is regarding the immediate release of the vessel, which should not be a problem in view of
fresh one.
This is a fresh matter relating to that same incident. Now today we are 83 days and counting. This vessel is stuck up there. My lords, I'll show the law. Not for a minute this should be allowed to be detained. My lord knows Sundarbhai Ambalal Desai. Then this High Court in division bench. I'll show my lord the words.
I received it yesterday only.
20th.
This is subject matter of the admiral suit which is going on.
Admiralty, no. I don't think. Admiralty is a commercial dispute with another entity.
The release of vessel is also a subject matter, should be a subject matter of admiral.
My lords, here it is arising out of 451 CRPC, which the court below has allowed. I'll apprise my lords what has happened.
The moment the vessel is taken out from this shore, then the jurisdiction changes.
My lords, it is not regarding admiralty. This is not regarding admiralty. Here it was a seizure under investigation under CRPC. We filed an application for interim release before the session judge. He has allowed it subject to some of the conditions.
Suppose I allow your application. Release the vessel.
My lords.
What will happen to the suit?
Suit, my lords, as such, there's an interim order.
Jurisdiction goes.
No. Suit, there's an interim order against us operating, saying that it cannot be released till the matter is decided. I appeared in the suit yesterday. And my lords,
the suit is going on.
Yes. And there is already an interim order there. Both these interim orders operate in different fields. My lords,
but it touches to the very jurisdiction of the...
It does. What falls from your lordship is correct.
Admiral jurisdiction goes and...
no, but then admiralty suit is pending. There's an interim order operating there. But both should not overlap each other. This is a criminal matter where the court has allowed, subject to conditions. Now, I am before your lordships vis-a-vis some of the conditions which are completely contrary to a series of directions of the
crew members are also detained in the vessel itself.
We are not seeking for release of the crew members. Let the ship be allowed to go. This is only vis-a-vis release of the ship.
Limited submission for my lord.
Multiple complications. It needs hearing. You give a copy.
My lord, even copy.
Just they have a advance copy. Let the extra copy be served to me.
My lord,
and lordship may keep it to 28th or 29th. My lord is keeping that matter.
No, my lord.
On the same day, lordship may keep it or
my lord may hear me on this. My lord may hear me on this.
No, there can't be any interim order on this.
My lord,
there can't be an interim
order. It can be on 28th, my lord. Every day, the loss that we are suffering is around 25 lakhs. Who will compensate us for this? Now, what is the mistake that we did?
There are ways to seek compensation.
My lord, may I submit one thing, my lord?
If you can make out a case of malicious prosecution, very well you can.
My lord, in a way, my lords, they are in contempt. My lord, may just give me 10 minutes. I'll show one judgment of this court. Muralidhar ka judgment. And my lord, my lord, may just allow me 10 minutes here.
Yes.
What my lord may see the impugned order, which is at page.
But in any case, I have to issue notice because
my lord may issue notice, but my lord may see. My lord may issue notice.
If I allow the vessel,
my lord, regarding interim release, I pray that let it come day after tomorrow. 2 days back, we have served copies.
My lord,
interim release means the finally deciding the petition.
Interim release is in consonance with the directions of this court.
Okay, I'll hear it. I'm issuing notice.
My lord,
file a reply.
My lords, they are in contempt. By not releasing the vessel, my lords, they are in contempt of a division bench order of this court, which says that it should be released within 2 weeks. We are at 83 days and counting. There should be some sanctity, my lords, to the laws of
where is the DB order?
My lords, I have given that.
Yes, this one.
Yes. My lord may kindly see. They are in contempt here by not agreeing for this kind of a release.
Regarding this same vessel?
Regarding this vessel? No. The direction is the moment vehicles are seized, you have to release it not later than 2 weeks. My lord may see that specific
My
portion.
lord,
I'll
it
show,
it is a case where the cocaine has been seized.
Yes. And
This
at
is
our
the issue
initiative,
for which the vessel has been.
NDPS analogy to this.
NDPS analogy
It cannot
across
be.
the
It will
board.
not work because this is inter-country
My lord, these are
jurisdictional issue and admiral suit is going on.
Yes.
You can't.
This
bring,
alternate remedy I will examine. Are there
NDPS
confusion
hearing,
proceeding there or not?
you can say that release the vehicle. How can it be?
My lord, may I be allowed to submit, my lord?
Yes, yes, definitely.
My lord, this judgment is across the board for narcotics also. I will show a compilation of various high courts where narcotics offenses out of narcotics. That compilation, my lord, may give. I was
That's precisely, Mr. Mishra, that's precisely what I'm
This is your
saying.
copy. This is court's, my lord.
Please supply the copy. It
Copy.
needs an extensive hearing.
Copies have already been served. All that I seek, my lord, is so far as interim release.
Dates.
A short date may be fixed. Not today. I'm not pressing for today, but in a indirect manner, my lord, they are in contempt. That paragraph only I may show from that judgment of the division bench.
Yes. Who is para? Para number?
This court takes note of Sundarbhai Ambalal, which, my lords, is the leading case.
Yes.
Then, my lords, may see 2000 para 9 Supreme Court judgment is taken note. Then para 10 Manjeet Singh is taken note of Delhi High Court.
Yes.
Then one important line which normally my lord would not find in High Court judgments, paragraph 13.
Yes.
It is clarified that hereafter, as far as release of vehicle is concerned, the directions issued in this order would prevail. This is very important. Normally, my lord doesn't find this. Then my lord may kindly see para 14. Articles, properties in general. Within 1 week of the seizure, properties seized by the police during investigation are to be produced before the court concerned. The concerned point number 2, my lords, is very important. The concerned court shall expeditiously and not later than 2 weeks thereafter pass an order for the custody in terms of directions of this court in Basava, Sundarbhai Ambalal, and General. 3 Supreme Court judgments. 2 weeks.
All these things are the vehicle seized in vehicle in the NDPS case and all.
Yes, NDPS. This is NDPS.
Is there any difference between a vehicle and a vessel in the sea?
Now, my lord, if my lord, this vessel is retained by them, will it inure to the benefit? That is how this has been analyzed in Sundarbhai Ambalal.
I have to examine how the jurisdictionally it would impact. So far, the release of the vessel will jurisdictionally impact the admiral suit.
It would not impact, my lords. This is under the penal vehicle. The vessel has already been directed to be released. We are only vis-a-vis 2 conditions. There is already a release order.
What are the conditions?
That my lord may see.
Yes, show me the conditions.
Page 1, once impugned order is annexure 17.
Page 177.
177?
My lord.
Yes. Okay.
Page 177, the order begins. The conditions which we are challenging, only 2 conditions. My lord may see at page 193.
193.
My lord. The operative portion of the order.
Yes.
Let the seized vehicle in question, that is MV Devi, so and so.
1 minute. Let me reach there.
I'm sorry.
Okay.
Page 193,
yes.
Running page.
Yes.
The operative portion of the order. A portion of this order is only under challenge. Let the seized vehicle in question be released in Zima of the petitioner, that is Asia Pacific, represented by author so and so, by executing proper Zimanama by investigating officer of this case, subject to the following condition. We are only regarding
10 crores.
10 crores bank guarantee, indemnity bond to the tune of 100 crores.
Yes.
And 1 solvent surety of the like amount. These are the 2 conditions that we are agreed with. So far as this 10 crores,
you are challenging the conditions?
Only the conditions. Only these 2 conditions.
The 100 crores indemnity and 10 crores
bank guarantee. This list is only vis-a-vis this. And this 10 crores out of nowhere, in none of the NDPS cases or in no offense.
Don't bring NDPS into it. This is something different. A vessel. Valuation has to be done. In the condition, indemnity bond is given on the basis of the valuation of the vehicle.
Indemnity bond, my lord.
And then you show me the valuation of the vessel.
My lord, may kindly visualize. Then, my lords, I have to show, my lords, all the judgments of the Supreme Court. Now, what they basically say is you require these things for the purpose of seizure and identification. The vessel, my lords, is
You
not
are
a part of
agreed
the
by the indemnity bond or agreed by the primarily you for
10 crores. First is 10 crores. No
RCMSC
court
page
granted.
192, the value of the vessel has been assessed.
Just 1 second. Let me submit.
commensurate with the value of
My lords, let me submit, my lords.
Yes.
10 crores, this cash deposit or this bank guarantee, which is as good as cash, none of the courts order this. This is not a condition ever in any criminal trial. This is, my lords, arising out of a NDPS case. I have given a compilation of all NDPS cases. All of them are on bond. Bond of this amount. Why this amount should be paid by us? This is a matter of seizure. So then, my lords, I'll show, my lords, all, in fact,
So then eventually what you are saying is the bank guarantee should be converted to a bond.
Bond.
And insofar as the indemnity is concerned, indemnity you will give.
Indemnity we will give, but
only the bank guarantee should be converted to a bond. That's what the long and short of your case.
Indemnity, my lords, 100 crores, one person, then I have to get big shots, my lords. Who has this kind of a solvent?
You are big shot, of course.
No, this much is not my net worth.
No, you are, of course, big shot.
So, net worth of 100 crores.
The fact that you are appearing indicates that your client is big shot.
No, my lords, that's in a lighter vein, my lord, that sounds good.
Indemnity bond is neither here now.
Yes. So indemnity bond.
Only the question
is indemnity bond.
I humble submission with my lord. Let me issue notice. I don't have any issue. But at least 7 days time may be given. In the meantime, what will happen? There is a 3 cases. One case is pending on that case. What is doing there? Next, I will take the instruction department whether against this order they have challenged or what sort of step is taken from the Ministry of Law for getting challenged same or not. Third thing, the whatever facts are coming to the court about the violation, all these things, we will also take the instruction in this regard. So, it is minimum 7 days time is necessary. Otherwise, we cannot let it in the court. We will assist the court in this manner. That's why I am praying. Let's see, keeping to 29. The same thing, same matter maybe because another matter was kept on 29.
Each day there is a
29 matter.
29, my lords. Each date there's a then this becomes infrastructure.
I'll keep Monday, Tuesday again. He'll come and ask.
My lords, may I submit one thing, my lords? So far as this 100 crores, we are agreeable for this, but one person we can't get. My lord may say 4 or 5 people. Otherwise, it's very difficult to get
You tell me. 12th February is the order passed.
My lords.
And we are today?
22nd.
Why have we wasted 10 days?
We
don't want to give the court 2 days also, 5 days.
I'm not saying
opposite side.
You
wasted 10 days.
My lord, we have come as quickly as possible. We have served copies. I'm not saying
they're entitled at least for a week. 29th. Let it be 29th, Mr. Mishra. Nothing is going to happen. Big shot, big vessel, big counter, nothing left.
Or at least on 28th, Wednesday.
Then let it be on 28th.
20th. Okay. That's
fine. Because it's
and take instruction whether you have challenged or not.
Yes.
The only area
thing is that
the bank guarantee can be converted to a bond. That's all.
Across the board, I have 3 Supreme Court orders. And across various high courts, Rajasthan is the leading high court.
And there are judgments where it says that property security you give. There are many kind of bond security, bank guarantee.
Narcotics only. Now, so far as this narcotics is concerned, that is under their seizure. They let them have it.
They have exercised under 42.
So that is not, we are not wanting the narcotics to be taken back or anything.
You want to take it back, don't spoil our country. You take it back and
now with the benefit of hindsight, my lords,
you bring narcotics to this country and leave it and go.
No.
And you take the vessel.
My lord, as a law-abiding world citizen, my lord, these people intimated. Now, this is what we are facing. Madam.
That's the only defense you have been telling right through. And then also, we have informed how it came to your vessel. You have to explain it.
My lord, had we not
and
told
what circumstances? Because you knew that if you not have been informing the police, they would have
submit one
thing. Eventually.
In our laws, my lords, the easiest release is that of a vehicle. So far as NDPS persons concerned, they don't come out.
There's 457.
Yes. The easiest release, no conditions attached, is the vessel involved. The vessel has not committed the offense.
But the confiscation is also contemplated.
Yes.
Now, if confiscation, then there are Delhi High Court judgments which say that if confiscation is contemplated, this personal bond is good enough because confiscation comes after the trial.
Have you initiated confiscation proceedings?
No.
That was no instruction. That's why
yes. If the confiscation proceedings.
One is confiscation, this is another is challenge or not.
457 is out.
Yes. No, my lords. No.
Two courts where they are coming to the court.
Requires a long drawn hearing, my lords. even if confiscation is initiated, we will, on a personal bond, we can take away these goods. I'll come with those judgments.
Two cases before my lord. One is now it is coming release of vehicle. Another is they are not to appear before the IO.
No, insofar as the IO thing is concerned, Mr. Mishra was not there on that day.
And
your statement
yes.
at the bar, on that basis, he will agree to that. That's what he was telling.
So
he will not be, his client will not be apprehended. He will come from
yes. Definitely, because in the stage of investigation, what actually apprehended, the question apprehended
kind of 41 notice kind of situation.
My learned senior friend can take instruction that so far as release of these items, it would be a huge burden for them to retain all this. That is what the Supreme Court judgment says. It is not my figment of imagination.
Trust also asked me this later, how will get our money? There is another thing is coming.
That cannot be the subject matter of a criminal case.
Because
it's unthinkable.
So we have to just see what will be the impact of this order, 12 February 24 order in the pending admiralty.
So far as pending admiralty operates in a separate jurisdiction, so far as port is concerned, there are specific provisions for them.
But I've just cursorily gone through this. That point is neither taken nor considered by the court below while releasing.
That is not linked at all to this. It is not linked.
I'm worried about one thing, whether the jurisdiction is diluted.
In the admiralty, my record my statement that in the admiralty suit, there is our undertaking that we will not leave till the matter is adjudicated there. Till that IA is disposed of in that admiralty.
You will not take the vessel out.
I have given an undertaking.
Then what is the urgency about it? If you have given the
that matter was heard finally yesterday, judgment is reserved.
Then in any case, you have given a statement that vessel will not be taken.
Till and we have given an undertaking
Then
so far as
it has a bearing. It has a bearing.
We have also,
you give an undertaking there. You want release here.
Yes. I'll tell my lords. Each day who will bear the costs of the losses that we suffer, my lords? These are huge commercial losses. My lords, ultimately the world is driven by commerce. Who will bear the losses? We obviously can't sue the government of India for this money. Each day, my lords, 20 lakhs is our loss. That means
you have realized 20 lakhs loss every day. That still on 12th February order you are challenging today. Coming. You could have mentioned anyway. 28.
So
28.
18 certified copy was given, 19 we have filed.
Anyway, 28 we are.
Let them serve. My lord is using notice.
Give the entire copy and compile.
No, they have served. They have already served. The extra copy may be served. Because there is a
give extra
issue.
in the course of the day it will be served. And compilation also. Judgment compilation.
Yes.
Okay.
And
I'll keep it at 3 o'clock.
Fine.
My lord, that we recorded that let me at 3 p.m. in the list.
Keep it at 3 p.m. Issue notice, Mr. Pari accept notice on behalf of the opposite party. Reach the matter on 28 at 3 p.m.
My learned friend would know, my lords, there was a very unfortunate case of MV Rose, where similar things happened and then the ship sank. So suppose it comes to this that our losses are higher than what we will recover, then there is a chance that these people may simply leave the ship and leave. Then, my lords, it's their burden. Let them do whatever. And salvage of these ships are not very easy. If they are looking at salvage, my lord, those judgments have specifically said that the decay that happens to a standstill vehicle is humongous. If we leave our vehicles unattended for 10, 12 days, it goes off. So if this is what they are planning.
Black Cruise also another example for this. Yes. They are giving everything unethically. And when they are going, they are leaving these things. These things also happened.
Yes. The vessel has to be treated in a different pedestal altogether.
According to them, this because it is a peculiarity case is there. That's why without instruction I cannot.
We call instruction. Let us,
and we were the ones who
try to place on record a counter.
Yeah.
So that
definitely
easier. On record let it.
Yes.
And seek instruction whether the bank guarantee could be converted to a bond.
That part I will like.
Yes. Okay.
That is in sync with the single decision of the Supreme.
I know.
Udit Jana is appearing with me. Let's me along with me. Udit Jana.
Yes.
We are all great.
I just come within 5 minutes.
So my prayer, Lordship, let it issue be notice and that will be.
They have compromised?
Lordship.
Okay, what is the offense?
4988.
These,
23.
the petitioners or petitioner? How much? Petitioners are seeking indulgence, petitioners have filed present petition, seeking quashing of the proceeding arising out of the FIR, arising out of GR case number 1311 of 2022. Books up. The land council of the petition submits that this is the matrimonial dispute and the parties have arrived at a settlement. Issue notice to the opposite party number 2. Mr. Ragada accept notice. Mr. Maharaj accept notice on behalf of the state and to himself. In the meantime, proceeding before the court before the state.
Lordship, for a appearance notice, sending notice is essential.
No, I have issued the notice. You bring them and we pass.
So notice is actually Lordship.
Notice for the
Notice ହେଲା ଆପଣ request ଦିଅନ୍ତୁ।
Yes.
27.
Let's frame for an action.
Urgent.
28.
May it please, Your Lordship. My Lord, item number 28, Your Lordship.
Yes.
Item number 28, my Lord. Recently, Your Lordship, on 20 तारीख दिन गोटे matter आसला, my Lord. CRLMC number 1.
Arjun. And tag this matter, my Lord. But both the matter will taken over Arjun to some other date, my Lord.
Which date?
My Lord.
Which is the date which is out?
4 March, my Lord. 6th March.
6th March. Which is the matter?
Along with CRLMC number 1659.
1659. 23, yeah? Okay. Thank you.
29.
My Lord, I have prayed for modification of the order passed. There is a small oversight.
NBW is issued against you.
Pardon?
You want that NBW should be passed?
I am coming to that. The order. Pardon. The order for modification prayed. The order said that in the instant case, the petitioner has approached the court by filing CRLMC 2173 of 2023, seeking the same relief. My Lord, in the CRLMC 2173, the relief prayed for was for quashing of the proceeding in Common Court. But here in this 3508 CRLMC, we have prayed for the quashing of the NBW issued by the Common Court after receiving the High Court order with liberty to file discharge petition, and discharge petition was intentionally, deliberately delayed.
He attempted to move an application to the meaning of yes, he was in the chair, we have to be although he moved an application, it became was not entertained and heard by the court. So the petition made by the petitioner is trying to be released. Yes, 239 application. I have said that 239 application should be heard.
239 application I had already submitted there just after getting the relief from the coordinated branch for filing discharge petition with the liberty.
What happened thereafter?
But they intentionally did not allow it. They told that magistrate is on a holiday. Let
that stage has not come, my Lord.
No,
My Lord, the earlier on the coordinate bench, my Lord, on dated 12/5/23, while disposing their application, my Lord, in paragraph 4, there are matters that can be considered the court below at the time of framing charge. CRLC is therefore disposed of, granting liberty to the person to move for discharge by filing an appropriate application in the court below, which needless to say shall be considered its own. The
thereafter
time
he
has not come, my lord.
No, thereafter he came to this court, say,
Man,
I moved the application,
What
was not heard.
move the application there. Man, he has to move the application after appropriate time. Man, he is not even appear before the court below. Immediately against him. While this court, my lord, granting liberty, them to appropriate time, my lord.
Every time last time you made the grievance that I moved the application, but it is not entered.
Rightly, man, not entered.
And I made the observation that if application is moved, it will
He
be
can move the application at the time of framing charge.
not
Not prior to that. NBW against him showing absence, showing absconder.
My lord, my petitioner is a government servant.
You are not sure about what you are asking. That's the full difficulty.
My lord,
31.
after getting the relief from the High Court, when I went to file the discharge petition there, I was prevented by the office that they will seek information, they seek instruction from the magistrate, and magistrate that time was on holiday, and it was the last. It was all stated in my CRLMC 3508. It was all stated. And here is
he challenging this.
And here is a copy of the application which they have received letter, but the magistrate order to keep it away and first implement the NBW order which the police had passed.
That has the discharge certificate, discharge petition has to file at the appropriate time, not when the case adjourned for framing was charged. By the time he has to approach, my lord.
For 10 years,
they were taking over the police. Non-mention in it.
It has already been described
that the person is not an actor. Hence, non.
The right now. When the NBW was issued?
NBW was issued on 12/6/2023.
12/6/2023. On 12/6/2023, NBW was issued against the petition. He moved an application for recalling the said order. The GNA cum JMFC Comna, while the impugn order has rejected the said application, inter alia stating that after the charge sheet was filed by the police, inter alia stating that the charge sheet was filed by the police, showing the petitioner is absconder. Neither the accused had surrendered before the court, nor the accused had surrendered before the court, nor has been produced by the police in the court. Hence, in the absence of the accused, his application to recall the NBW cannot be entered. Therefore, the application of the petitioner has been terminated. The petitioner seeks indulgence of this court and these states. Peruse the record. And the order passed by the coordinate bench of this court. So taking into consideration the facts of the present case, and the statement made at the bar by the letter cause for the petitioner, the petitioner is directed to appear before the court on or before 15th of March 2024 and seek remedy before remedy available to him under law. Till then, the NBW issued against the petitioner on superintendent legislator is kept in abeyance. Word, sir. Dispose. Yes.
30.
Yeah, please, my lord, in this case, I filed a withdrawal because the previous counsel did not give consent. I filed a wakalatnama. The petitioner himself has come. He wants to withdraw. Yes, my lord.
The petitioner is present in person and represented by the counsel. Full stop. The petitioner makes a statement that he doesn't want to proceed with the matter and seeks withdrawal of his petition. On the basis of the statement, the petition is dismissed. Yes. Yes.
31.
There are two matters.
Both are okay.
Both the matters.
Please, your lordship.
Yes.
Lordship, here the petitioners have prayed for quashing of the proceeding on the ground of compromise. And
yes. Are they? They are present.
No.
Will you call them?
No.
Now, will they come to the court?
No.
Why?
No. Appearing the.
That's what I'm asking. Will they will have to come? The accused are not VIP. They have to come. Accused
Yes.
committed a
Yes,
crime.
your lordship.
When?
Your lordship may.
The notice was issued to the opposite party number 2 on 11/1/2024. Mr. Florida entered appearance for opposite party number 2. Settlement is done.
Yes.
And submits that the parties have already settled the dispute. Parties have already settled the dispute. He files an affidavit to that effect as well, which is taken under court. Leaves the matter on Saturday for appearance of the parties. Monday, Tuesday?
Lordship may Tuesday.
20. Bring them, we'll pass.
27th.
Thank you.
20.
32.
32, your lordship, kindly be taken up next week.
Adjourn.
Because, okay.
Yes.
33.
May I please, your lordship? My lord, on 1/2/24, your lordship have passed the order to file requisites by 2/2/24. But as 3 and 4 were Saturday and Sunday, second was, my lord.
What do you want? You tell me.
My lord, I need time to file. I have filed requisites on 5.
Right on 1/2/124. Notices were issued to opposite parties number 2. Requisites could not be filed by the petitioner. Therefore, he seeks further time to file requisites. Let the counsel for the petitioner file the requisite within
2 days.
Within 2 working days to serve the notice on opposite party number 2 was days of time. April. Yes.
34.
This matter, my lord, Mr. S.C. Mahapatra, senior advocate, is appearing. I think he'll be on VC, I assume.
He's on VC? No, he's not on.
No.
He
said he would be on VC, but probably I think just one passover.
I may please your lordship.
Yes.
The petitioner, based upon compromise, your lordship filed the petition for quashment of the proceeding
You have settled
And
the
I sent the notice and
My lord,
they have also filed a case before the Honorable Court. And
what is the offense?
379, 448, 34 IPC. 379, 448 and 34 IPC. Charge file.
Charge file.
Mine.
Okay. Where are they?
my lord, I am appearing for the opposite party in this.
But where are the
My lord,
parties?
parties. My lord, he is at their residence. My lord, at Bhadrak. My lord. My lord,
He
my
will
lord,
be in the residence only.
my lord, I have today I am appearing on behalf of the opposite party number 2 in this case.
Mr. So-and-so enter appearance on behalf of the opposite party number 2, files Vokalatnama,
And-
states that on the next date of hearing, the parties would appear before the court. Appear before the court. Since the parties have settled the dispute, petitioner and opposite party number 2 may appear in the court in the next date of hearing.
My lord. And
And in their case, I am appearing for the opposite party number 2.
My lord, in the tagged case.
Tagged case.
So,
And that is also there.
Okay.
My lord, I am pray one thing. The proceeding may be stayed. That is on 16th of the March. I have filed a petition to that effect. Inadvertently, that stay operation
in the connected matter.
connected. My lord, in my matter.
In the sub item number 35, na?
Item number
35.
Then sub item
5216.
in the meantime, the proceeding sub item. Meantime, proceeding that is also state.
And your lordship may kindly directed to release this matter along with the CRLMC number 1346 of 2021. 1346 of 2021. 21.
This matter.
It is not a
ଆପଣ reference ଦେଇଛନ୍ତି ଯୋଉଟା ମୁଁ ସେଟା କହୁଛି 1346 of 2021
କଣ ଗୋଟେ ଫାଇଲ କରିଦିଏ ଦେଖିଦେବା
ସେଟା ଟିକେ ଆସିଥାଉ କଣ
no problem I have stayed it come on
ସେଟା ଷ୍ଟେ ହେଇଗଲା କିଛି ଅସୁବିଧା
କେବେ ଆସିବେ ପାର୍ଟି
on 12th, my lord, fixed up. On 12th of March.
12th March. Yes, 36.
May I please, your lordship?
Yes.
Also, herein, your lordship has directed the learned state council to obtain instruction so far as why the final form is not filed yet. The final form has not been filed by the prosecution yet. The FIR is of 2022, your lordship. Your lordship has directed on last 2 occasions to obtain instruction.
Only instruction. I have not said that final form or anything. What is the instruction?
Something is urgent to remove defect on 11/1/2024.
37.
37.
Instruction I see.
No, my lord, I have not received.
Awaiting instruction from the IIC. Which IIC?
IIC
Baripada town.
Portugal.
37. Baripada town.
Yes.
Instruction has come.
Yes. Well, instruction your lordship directed to regarding progress of investigation. My lord, the investigation all statement has been recorded and very soon the charge sheet will be filed. But enter CD I have obtained. Enter CD along with the statement.
Can I trouble your lordship for a moment? Lordship, may peruse the 164 statement.
Yes.
Only after the intervention of your lordship, a few days ago, the victim has, the prosecution has recorded the statement of the victim, your lordship.
13th February 2024, 164 statement.
13th February, your lordship, last week.
What does he say?
My lord, I am reading. ମୁଁ ଆଜି ତା 13/2/2024 ରିଖ ଦିନ ଉପସ୍ଥିତ ରହି ଏବଂ ଭଗବାନଙ୍କ ନିୟମ କରି ବୟାନ ଦେଉଛି ଯେ ପାଲବଣୀ ବ୍ଲକ huge file everything has been done.
You have invited him. In these kind of cases, it goes slow, then time will take its own course. And you are forcing the police to file the charge sheet against you. You have invited all.
Actually,
over anxiety is the creating problem. The moment FIR is lodged, you come to the court, quash it.
No, your lordship, this is of 2022, your lordship.
22 and we are
24.
24 only, beginning of 21, 1 year. Anyway, so, yes, next.
Much obliged.
On behalf of Mr. J.K. Ratha, I pray for an urgent.
Urgent.
38.
Yes. 39.
39.
May I please, your lordship? In this case, my lord, I am challenging the charge sheet, my lord. Charge sheet. Not cure the defects also. What? Anyway, my lord. Yes. Why charge sheet? You are challenging?
Charge sheet filed on. My charge sheet filed on 31/8/2022.
Yes.
That is find you also may kindly page 25.
Yes. Annexure 3. Man. What happened thereafter? Charges and everything is same.
Charge sheet has been filed and he has prayed for quashing of the affair, disputing the marriage.
Disputing the
Marriage.
that is a tribal thing.
40 টা withdraw. 41 ଟା ଆପଣ 41
Entry order ଅଛି ନା?
41 independent party.
Oh, that's the problem.
ବହୁ କ୍ଲେମ କରିଛି ଶ୍ୱଶୁର ଆଉ ଶାଶୁ ନାଁରେ
ଯାହା ବି ହଉ ଆପଣ
ବହୁ ବି ୱାଚିଂ ଲେଡି ଅନରେବଲ କୋର୍ଟ ରିଫ୍ଲେକ୍ଟେଡ ଅର୍ଡର ଆମେ ଓଜନ କରି ଠିକ ଦେଇଥିଲୁ କେତେ କରିଦେଇଥିଲେ ଆମେ ୱାଚିଂ ରେ ଥିଲୁ ଯାଇଥିଲା ଇସ୍ୟୁ
once you take entry order, all these things stamp come ଅଛି ଏଟା ଅଛି requisite file.
ପ୍ରାଇଭେଟ ପାର୍ଟି କରିଛନ୍ତି ଆମକୁ ବି କପି ଦେଇନା.
That's the reason I don't give entry. All kind of pretext. This is not, the court is not going to examine how much you paid, 2 rupees you have paid less, or 5 rupees you have paid extra. You have got a stay order, and it is your duty to ensure that the service is effective.
Yes.
You don't do it and come to the court.
ଇସ୍ୟୁ କୁ ଯାଇଥିଲା କିନ୍ତୁ ଫେରି ଆସିଛି ଓଜନରେ କମିଗଲା କହୁଛନ୍ତି
ଆପଣ ଏକ୍ସଟ୍ରା ଟିକେ ଦେଇଥିଲେ
Adjourn it.
ନାଇଁ ଡ୍ୟୁରିଂ ତୁମର ୟୁ ରେକ୍ଟିଫାଇଡ ମାଇ ଯଦି କିଛି କମିଛି 5,000 ଟଙ୍କା ଆମେ ଦେଇଦେବୁ.
You have taken an interim order from this court.
My lord.
Once you take an interim order, it is your responsibility to take necessary steps to serve the.
ଓଜନ କରି ଦେଇଛୁ ଠିକ ଥିଲା
That is the reason I don't pass interim order in 480. The moment interim orders are passed, and this is the employee
ରିଫ୍ଲେକ୍ଟେଡ ଇନ ଦି ଅର୍ଡର
for adjourning.
ବହୁତ ୱାର୍କିଂ ଲେଡି ଆମେ ଫାଦର ଇନ ଲ
Okay, it's all right. Adjourning. Is whatever. Yes. 42. We'll see. 42. 42. Some deterrent has to be, you know, pending is increasing and this is courts are piled up with this kind of matter. Unnecessary.
42.
May it please your lordship. In item number 42, I am for the petitioner.
Yes.
On 7/2/24, order was passed to file the notice and requisites for registry
This is
for the
I think this is Union of India
42.
because you have not served copy and
No. It's a private party.
Union of India is written
42.
42.
Private party.
Private party.
Yeah. Private individuals.
Okay.
So here the order was passed to file the requisites. I have filed the requisites. However, in the meantime, OP number 1 has changed the address. So I have filed the requisites with the new postal address and along with a memo. So now the office is saying that it needs a court's order. So that is why I mentioned it.
No. Service.
Day before yesterday also I mentioned it. I have filed the requisites on 9/2/24.
No. Service on opposite party. No.
Service.
Opposite party. What is the position?
लेट फाइलिंग है तो तुम्हें एक्सेप्ट है नहीं.
नहीं, late filing है नहीं. The notice has been filed. The requisites have been filed in the due date 9/2. It's just that the address which I've mentioned in the petition and the address which I've mentioned on the envelope to be serviced, that those are not similar. They're not same because the OP number 1 has changed the address.
So you have changed in the petition also. You have changed the
So do I need to file a new petition?
The letter council for the petitioner submit that.
I have given a
change
memo
of
for the
address.
same.
There is a change of address up to the opposite party, and he has furnished fresh address. he has furnished the fresh address, and fresh address. And seeks permission or leave of this court to serve the opposite party number 2, opposite parties in the fresh address furnished by her. This notice to the opposite parties on the fresh address on filing the requisites within 2 days.
Yes.
File the requisites.
I have filed all the requisites. my
Requisites has been filed. Serve the notice in the fresh address.
OP number 1, the new address needs to
Yes.
be served upon.
Next.
Obliged, Your Lordship.
Beg your pardon, Your Lordship, on behalf of Mr. A.K. Singh, I am seeking for passover.
Passover would be a difficult thing, Your Lordship. 43.
Yeah,
I'm there for the informant, Your Lordship. You are asking for passover for whom?
A.K. Singh, Ajit Kumar Singh.
For petitioner, my lord. She's asking for a.
No, true it is, but the difficulty is, my lord, my schedule gets disturbed because other matters are there.
What is this matter? You are for opposite party.
I am for the informant.
You are suffering the interim order.
Mine.
Then let it be some other day.
And then, my lord, please, on 7th March.
He always prays for a long date. I'm not advanced. He can do. He's doing it online. He can always do it on online because he's, I think, from Delhi.
That's why you're asking for passover. I have to thank
He is
you.
the Ajit Kumar Singh. He is
Yes.
there in 43. He is online. They're on. Just see.
No, he does it on online most of the occasions. I do not know if he has physically appeared on any occasion. So he can very well do it on any day. It is not necessary that that should be always a longer day. That's what I am subject to your lord.
7th, he can come, my lord. 7th March.
As your
What to
lordship
do?
pleases.
Before that also not possible.
Yes,
As your lordship.
please.
Huh?
As your lordship.
Completely packed.
As your lordship pleases.
So that's the whole difficulty. Digital. 7.
Obviously.
I believe my friend can also do it, but he is not doing it.
See,
I'm not instructed by my senior, my lord.
then I pass it over, seek instruction now.
In general.
See, he wants a opponent like you. So that
It is not that way. Your lordship is always there to correct us. Whosoever commits a mistake. So
no,
therefore,
I love to hear youngsters and they should
and so
avail the
therefore,
opportunity.
it is
I'll
not
not
that,
pass any adverse order if you
and
if you can't convince the court or something. I'm simply adjourn, but may have an attempt. Have an attempt and try.
and the other parties, even if she will not be able to place something, your lordship is always there to appreciate from the record. So,
You should avail the opportunity of arguing.
both sides is secured that way, my lord.
Will you argue in the shorter date I'll give? 7.
Hopefully that day, if Mr. Singh is absent, she will make an attempt.
He will be ready now. Yes.
44.
Whatever may I please see. In this case, my lordship, the present petition challenging the questioning of entire criminal proceedings that which has been pending for
What about the notice part?
notice has not been served to the opposite parties, my lordship.
You have opposite party number 2. You have implemented opposite party number 2 or what?
That what happened, my lordship, in this case, my lordship, in annexure 1, the present petition number 1 is the rape.
Mediation report.
Yes, I am suffering. I am the opposite party number 2, my lord.
But there is an entry model.
I am placing the case. I am not praying for deferment.
Not arguing.
I am not praying for deferment, your lordship.
Let us hear it and if he
My
has
lord.
a case, allow.
My-
Otherwise dismiss.
My lord, so I am not praying for adjournment. So my friend should not have a grievance that way. He has mentioned, but possibly
He
right
is
to
not making grievance, he is scared of you.
No, mate ke scared ho nahanti.
Yes.
Otherwise, I would not have been abused by many in open court.
That is the affectionate abusers and you have to take it to your own side. Okay.
But
Yes.
here,
What is the case?
I will demonstrate a case where there has been a flagrant abuse of process of court so far as the prosecution of the petitions is concerned. My friend,
You are challenging the cognizance order.
cognizance order,
Yes.
but I'll just place few sequence of events your lordship will see, and if your lordship feels this is not an abuse of process of court, then I have no case. Initially, one 1cc case was filed
Yes.
My lord, I am sorry, one PS case was filed under Annexure 1. I beg to draw your lordship's kind attention to Annexure 1.
Yes, thereafter charge sheet was filed.
My lord, there I will only point out two dates, my lord, page 10.
Yes.
Your lordship will see incident of 28/4/2016 ରାତି 12ଟା ଆଉ ଗୋଟେ ତା ତଳକୁ ରାଇଟ ହ୍ୟାଣ୍ଡ ସାଇଡ କୁ 8/7/2000 ରିଖ ଦିନ 10ଟା 16 ଦିନ 10ଟା. Purpose of saying is how the abuse has been happened. I will point out that. Now this was investigated upon. Your lordship will kindly turn to page 17.
Charge sheet.
My lord, may I just place few portion of it with your lordship's kind permission?
Right.
Towards the middle of that paragraph, your lordship will find in the year 2012, Manoj Naik came to know that his wife is taking various medicines without his knowledge. On being asked, the complainant stated that she has no knowledge about the disease and stated that her father, Harihar Naik, told her to take the medicine in time. Subsequently, he could dictate that his wife and the complainant of the case, suffering from schizophrenia disease and undergoing treatment before Dr. Samarendra Mahanti, consultant neurosurgeon, psychiatric at Cuttack. After knowing the fact from his father-in-law, Manoj took sincere steps for her better treatment. After consuming many medicine, no change could be noticed in the abnormal behavior of his wife. On dated so and so, Jhunu Priya asked Manoj to accompany her to the village temple, but Manoj
48, my lord, I am appearing for OP number 2, my lord.
Nobody is there. Mr. Stone so enters appearance on behalf of opposite party number 2.
And my name reflected
Party
in the
number
document.
2 and files for Kalatnama. They be taken on record. Matter is adjourned to take video for the hearings. Yes. 49. Yes.
49, my lord, on the last occasion, my lord had wanted to file the requisites so that notice can be issued to the opposite party, not to my lord.
Is appeared.
OP2 and 3.
Yes. What is this matter?
My lord, this is an application under section 482 for quashing of the entire proceeding. But in fact, my lord, my main grievance is that inclusion of section 307 in the charge sheet against the petitioner.
What is
My lord, I have
in the charge sheet?
My lord, I have, yes, my lord. That charge sheet
Is it page?
Charge sheet is at page Annexure 4, my lord, page 24, my lord.
Yes.
My lord, and on the last occasion, my lord, I had filed the certified copy of the injury report of the alleged injured as well as the bail order of this petitioner in the lower court below, my lord, wherein it has been so it is revealed that the injured has not sustained any injuries, and all the injuries are simple in nature, my lord.
Now, simple in nature will not take out your this thing for the charge, because the intention is to be seen. Which part you have? Which part of the body you have?
Throat.
My lord, my lord, may kindly.
You will be acquitted. You will be convicted in 323 or 320.
That 324 is there, my lord.
Don't know what was the intention.
My lord, the fact is that, my lord, I have also filed an FIR, and my lord had also issued directed the State Council to take instruction as to what has happened on the FIR filed by this by the.
My lord, the orally, my lord, I taken instruction from the IAC, my lord. He stated that there is no such FIR, my lord.
That
no
my lord,
case registered,
Annexure 3, my lord, may kindly.
Annexure 3 is there.
Yes, ma'am.
Orally, my lord stated I have instructed him to give written instruction. He stated that there is no such.
Then awaiting the instruction from the
My lord,
IIC,
Annexure number 3, my lord, at page 23.
IIC Banchali.
My lord.
PH.
Bodasai.
My lord, he has received the copy.
Huh?
But
he has received the copy of the FIR filed by
he has
the.
not got the written. Awaiting the instruction from IIC Bodasahi, IIC PS Bodasahi. The matter is adjourned to You seek instruction, or written instruction, let it come, we'll see.
I will.
Okay. Give it. Yes.
Item 20.
Yes.
My please, lords. Hear me, lord. On the last occasion, my lords, was pleased to direct me to serve a copy of the written note of submission along with the judgments. The case, my lord, background purely a civil dispute is given a color of criminal texture. That is the reason for which I have come up to your lordship for seeking for quashing of the judgment, my lord, quashing of the affair.
For the other side?
No, that said, despite of notice, he didn't appear. Prior to filing this affair, he had invoked the jurisdiction of the land civil court, seeking for declaration that the sale deed are illegal and the power of attorney executed by him, alleged to have been executed by him, is not genuine one. Allegation is in the affair that one Sairam Sahu.
Just check it up. What is the service? Yes.
Yes, your lordship checked up in the last occasion. Again, let it be checked up. Notice was made sufficient.
There is a suit pending already.
Suit prior to filing of this affair. He didn't disclose this fact in the
Yes,
affair.
written submission he has given. The last order says.
And I annexed
you
all
are
these three
supposed to-
relevant
Mr.
judgments.
Maharaja, you are supposed to appear in.
There is absolutely no
Because-
allegation in the affair against me.
You, written submission is given.
Here I mention written submission and a
I
copy
have
of the
given to him.
judgment. This is not yet received.
I have personally served upon him. That service copy is with me.
Just check it up.
Say
Because
it,
last
huh?
order was, you were supposed to give you written submission.
Yes, I have given. The copy is with me. Personally, I had served. ସେଠି ଲାଗିଯିବରେ ଆପଣ ମତେ ଦୋଷୀ
ଅଛି।
ଫାଇଲଟା ତାଙ୍କ ସାଇଡରେ ରହିଥିଲା ଫାଇନାଲ ସାଇଡରେ ରହିଥିଲା ମୁଁ
Prepare କରନ୍ତୁ।
ଆଜ୍ଞା।
I would date it.
Would date this. Simply urgent, entry order to continue.
ସେଟା ମୋ
No, there is no interim order in my favor. My lord,
29.
I pray early date, my lord. Early date.
Why we, I can give an interim order.
Interim order, I am not prayed. The investigation not yet completed. I am under
Okay,
protection.
still investigation.
Investigation.
Okay, therefore no entry order. Okay, short date.
So, sir.
And we seek instruction, what is the position?
already taken CD enter thing is there.
Case is made out.
2 p.m. 2 p.m. and taken up.
Huh?
Yes.
Case
2
made
p.m.
out.
2 p.m. Your lordship take up this 2 p.m.
2 p.m.
As your
2
lordship
PM
take it, I
and
am
today it may not be possible.
any day next week, my lord? Week after.
He will find out a date.
Week after.
And bless you.
Oh, bless.
51.
Item 51, I am appearing for OP number 2.
ଆପଣ ପଡିଗଲା ନହେଲେ ପଠେଇଦେବି
1 week time may be given for filing the objection, your lordship.
Yes. Yes.
I am appearing for the OP number 2, your lordship.
Yes.
My 1 week time may be given for filing the objection, your lordship.
You want to file objection, sir?
Your lordship had also directed the state.
12 1 minute the another date may
Instruction.
Mr.
କିଛି ଆସିବନି election ଆସିଗଲେ।
Seems so much.
So I prefer Saturday.
12th, na? 12th, you want 12th,
Madam.
no, we did, 12th will not.
12th.
ତ ନମ୍ବରଟା ଏଠି ଲେଖିଦେ।
After reading the legal. Right, 20. Don't so appears for the opposite party number 2, files Bokalatnama, the same is taken on record, for further hearing, please search.
Previous order state to comply.
State, Mr. Ragada, submits that he would be seeking instruction, by next data. Yes.
52.
If senior is waiting, let us ask what is this matter. Ask him. Ask him. Yes.
52, I am for the opposite part number 213.
Item 52, na?
Last occasion, your lordship directed to file the joint affidavit, my lord.
No.
Oh, the settle, huh?
Settlement, matrimonial dispute.
Matter has been
Where
settled.
are they?
I am for the petition, my lord.
Where are parties filed by the Bangalore police, huh?
Jigani police, my lord, it is a Jigani police station.
Jigani PS, Karnataka.
District
of Bangalore. Karnataka in crime number 242 of 2023.
Yes.
Which is taken on record. Mr. Maharajas seeks time to file the copy of charge sheet in which
And Sarangada PS case number 137 of 2023.
Sarangada PS. He may do so during the course of the day. Supply the copy of the same to Mr. Das. Senior counsel. Leave the matter for hearing. Give it. Take it on record and.
Can it be, 6th of March, my lord?
6th March?
6th
March, okay.
Yes.
Yes.
Okay. Yes.
Yes.
For the opposite party.
Opposite party? Yes.
Opposite party.
What is this matter? Yes.
I am the petitioner here.
Yes.
Lordship, I look at the certified copy of the order sheet I have filed at page 9.
Page?
9.
Yes.
Lords, this is a complaint which was filed on 3/1/2023. On that date, it was directed to be put up letter for office note. Then the letter order shows put up on 7/1 for filing documents and inquiry. 7/1, my lords, documents were filed, tagged with the case record. Direction is put up for inquiry on 6/5. Then, my lords, he takes adjournments. And on 1/7/2023 at page 11, he files a petition to advance the records. And the complainant is examined on 22/7/2023.
This is
Your lordship knows.
53.
The case record is put up on strength of advance petition. Heard, prayer allowed. Complainant so and so is present and files Hazira. He is examined under 202 CRPC and discharged. There is no examination under 200. The court straight away goes to 202 and then takes cognizance.
What do you say?
Lordship, while in custody, the petitioner was brutally assaulted by the respondent.
Don't go into the fact. He is pointing out without resorting to 200, 202 statements are recorded and cognizance is taken.
That's the
That's
fact.
what,
On that fact, I am not disputing.
sorry?
I am not disputing that. It's a fact. Lordship,
They are disputing, obviously. This is a case record, you can't dispute that. They are proceeding, but how do you address it? You tell me. You are not prepared in that line, it seems. In that line, that is the case. He is putting forth, that is how we challenge the cognizance order. Because procedure contemplated under CRPC is not complied with, that's what he says. Yes, Mr. Maharaj.
Yes.
He has to, he is not prepared.
My lord, your lordship may kindly turn to page 10.
But he is the informant, the
Yes,
complaint case.
He is, you will argue or your senior will argue? That is. No, that has been followed.
Fundamental Mr.
This has to be set aside and
Mr. So-and-so appear for the opposite party number 2. Mr. Panda, by referring to the proceeding sheet of the court below, argues, submits that without following the, undertaking the rigors of the procedure under
that is in chapter 15 of this year.
Procedure under chapter 15 of CRPC, the trial court has the court below has taken cognizance of the offence against the petitioner, which he assails. The counsel for the opposite party, number 2, states that in that line he has to prepare the case and address the court on the next hearing. Matter adjourned to so entry order to continue.
May I please, my lord? My lord, this is a matter where, my lord, Domestic Violence Act has been misused, my lord.
Interim order, my lord. Interim order to continue.
Oh, interim order will continue. 43 Samir Mishra appear.
Hi, Lovelace.
Any adjournment?
I may be pardoned to mention, my lord, item 33. In that item, my lord, I have already filed the requisite. I have filed the requisite.
Which item?
Item 33.
It is passed over?
No, sir.
You have not filed requisite, that's the report.
On the item of the
Noting is there, my lord. I have filed the requisites on 5th.
We'll see it now. When matter was called up, you are not there.
No, my lord, I was there.
Then
but,
why have you not pointed out?
I have not pointed out that it has been filed on 5th. It is mistake on my part.
Just take it up and.
Pardon, item 57, madam.
Yes.
My lord, I recollect 59, sorry.
I'll take it up after lunch.
As the launch for us.
Yes, Mr. Luthra, you. want to
Item
mention-
58, I want to do the matter. The only difficulty is I have a specially listed matter at 2 p.m. If my lord may accommodate me at 2:30 or so, my lord, or pass it over and take it up again, lord, because at 2 o'clock I'm in a little bit of a challenge.
Yes. See, there are a couple of passover matter. By the
Great,
time
sir.
I'll take up those matters, I think you will be free.
I'll be most grateful. Not my matter will take 15 minutes here, but 2 o'clock I'm committed. Great.
Very good. Very good. dated so and so, undertaking so and so was registered against the petitioner. The petitioner happens to be a developer, and the opposite party number 2 was a customer. He has invested money for the
Purchase of 2 flats.
For purchasing of 2 flats in his name. Since the flat was not delivered after taking the consideration, the case was filed against the petitioner. The petitioner and opposite party number 2 has now settled their dispute, and as per promise, settled their dispute. As per promise, the petitioner has delivered the possession of the flats to the opposite party. One flat to the opposite party, and
Rest is refunded.
and rest of the amount he has refunded to the satisfaction of the opposite party number 2. The parties are present in the court. They are represented by their respective counsel and being identified by them. They have filed the self-attested copy of the Aadhaar cards on record. And they have also filed separate affidavit dated
Joint affidavit.
joint affidavits.
One joint affidavit and another compromise affidavit by the informant.
Okay. They have also filed a joint affidavit dated 22/2/2024 and a compromise affidavit dated 22/2024. Both the affidavits are taken under record. On the basis of the Mr. Maharaja appears for the state and submits that since the dispute is primarily inter-se party, and since they have settled their dispute, there is no legal impediment in watching the present FIR. On the basis of the affidavit, joint affidavit, and the compromise affidavit, as well as the fact that the parties have settled their dispute amicably, the present petition deserves merit. Next further on the facts and circumstances. How much cost? 1,000 for a developer.
1,000
You are paying to the bar only.
Yes.
How much you will pay? What was the cost of the flat?
What
was the cost of the flat? 5,000.
Respect.
Flat must be to some crores.
No.
18 lakhs. 80.
18, not
1,800,000.
Since long it was
2011.
11.
18 is big money that time. Okay, anyway, 5,000. Okay.
24.
Item 24, my lord. Due to my wrong mentioning of case number, the matter has been listed today again. I have given the certificate stating that the pending bail is 13,000, but it is 13,606. That is, it is pointed out by Lawrence Senior.
No, which one? Which order?
Not order, my lord, in the page number. Certificate is the pending case number is 13,606. I have stated 13,000 in my CLMC petition wrongly.
I gave dictation. What
Lordship had issued notice, but subsequently when Lordship came to know that the certificate is wrong, Lordship kept it today.
He requested me to excuse for that.
Wrong. My wrong committed
because I made a submission that he has.
Yes. Subsequently, you
yes. That is the fact. Because yesterday, this case was there in the list, and the anticipatory bail filed by this same petitioner was in the another.
What happened there?
That I don't know.
That is pending. It is fixed to March.
And my brother is also for the petitioner.
Yes. But the number I have given, I have wrongly given 13,000 the name of the anticipated bail application.
So what to do now?
I will correct it. I will correct it. I will take
the counsel for the petitioner seek leave to correct the what is it? Correct
page number 2.
Certificate.
Correct the certificate he has furnished regarding the earlier case he has filed before this court, the same, he may carry out the correction in the court, countersigned by him, and issue notice to the opposite party number 2. Opposite party number 2. Returnable within so Mr. Maharaj accept notice on the
Hon'Ble. I'm sorry for the wrong
It's all
comment.
right. No, this happens. We have to correct things if.
There was a
but you have
misunderstanding
written
in the court.
13606.
Right.
It should be
13606. It should be 13606.
it is, in the file. It is there already.
13600.
When you corrected,
I didn't correct.
it is in front of me. It is corrected one.
No, I have not touched the file.
It is corrected this.
So wrong copy has been given to state.
नहीं कथाटा ठीक करी आपण कहि पाउनांते जे जो रेफरेंस देचंती दैट इज राइट, दैट इज नॉट ए मिस्टेक, दैट इन रेस्पेक्ट ऑफ co-accused, that reference is respect of co-accused. So far this petitioner is concerned, he has not given his reference. That a application has already been pending before this.
That's what is his case is 13606.
Yes.
13606 is his application. 13600 is the co-accused person.
But 00 is not given here.
That wrong copy I have submitted to the state. That is my honest senior.
In the court he has filed.
And he is also holding that file. He is also holding that file.
Why are you to countersign here? Don't do that. Countersign. You have already corrected it. Countersign. We don't know. It is corrected yesterday or today or I don't know.
Rightly filed as wrong copy to the state.
Well, anyway, don't get into all that. Just countersign and finish.
Finished up.
Yesterday, I don't know. Yesterday it was the 13600 or what? I don't know.
I have not touched. Today
এই কপিটা মু দেইଥିଲି
80 কিন্তু কারেকশন হইলা
সেটা সেই তো
ফাইলটা কিন্তু কারেকশন হলা
সেটা রাইট রেফারেন্সটা দিয়েছে রেফারেন্স রাইট বাট হি হ্যাজ নট গিভেন হিজ রেফারেন্স দ্যাট ইজ দ্য হোল ডিফিকাল্টি দ্যাট ইজ হোয়াই আই হ্যাভ গিভেন দিস অর্ডার
Yes, this is Anshuman Sauna and I got that order also now. No, that is 13.3. 13.3. The order is 13.3. Got the order. Keep it in record. 13.3/2024. Interim order passed earlier.
No, Lordship issued notice returnable on by 18.3. This case. Yesterday.
Yes.
Well.
What is the date now? 18, huh? 18.3. Next date. Yeah?
Okay. No interim order.
No, both ways. Miscase and both.
Yes.
34.
Yes, sir.
The petitioners challenged the order of cognizance. Cognizance was taken on section 276B and 278B of the Income Tax Act, my lord.
Yes.
Actually, what happened? The petitioners, they deducted the money at source, but failed to deposit in the time.
Now have you deposited?
Yes, it is the case of the prosecution. I have deposited with the penal interest. And thereafter the prosecution was launched, sanction was obtained. So my humble submission that prior to obtaining the sanction and lodging the complaint, if the money was deposited with penal interest, then the prosecution is not tenable.
Issue notice to the opposite party number 2. Opposite party number opposite parties.
Opposite parties.
Parties returnable and so on. In IA, right on. Mr. Mahapatra, the senior counsel appearing for the petitioner, submits that his client has been subjected to prosecution under section
276B.
276 capital B. Take it from page 11 of Income Tax Act. and accordingly cognizance is taken. He submits that the text deducted from source was not deposited by his clients in time. However, subsequently, along with the penal interest, he has his clients have deposited the TDS. TDS. Thereafter, the sanction was obtained from the competent authority to prosecute the petitioner, which is not sustainable under law. Sustainable in view of the aforementioned position, aforementioned submission made by the senior counsel, the proceeding pending before court of ACJM special Cuttack.
Additional CJM special Cuttack.
Learned ACJM special
Bracket special Cuttack in 2 bracket small e bracket close CC case number 05 of 2023 is stayed till further orders. There is give a date in April. Yes. Yeah.
Filing a appearance of memo, my lord.
Appearance memo.
Oblige, my lord.
Yes.
In view of that compromise, my lord.
How much? 1,000?
No, my lord, that is past of without prayer, lordship kind enough to case.
Subject to the petitioner paying 5.
Petitioner no, my lord. 500. The opposite button. Petitioner.
Both of you deposit 500.
Both parties, 500 each.
Why should you distinguish?
Both parties benefited.
Petitioner
And opposite party.
Depositing petitioner দুইটা কেস হচ্ছে না গোটে ইয়ে petitioner গোটে আপন petitioner
Yeah, petitioner hin na prayer hin
Opposite also
without prayer my lord your lordship pasti
according to compromise
GR case there is no such prayer but your lordship kind enough to cast the
yes
only one case
subject to 1,000 rupees cost
500 each my lord.
ठीक है
compromise ଅଛି
yes compromise
Number 1 is husband and others the petitioner number 2 to 4 are family members of petitioner number 1 my lord. The opposite party number 2 is wife of the petitioner number 1. Offense alleged to have been committed by the petitioner number 1 and others under section 498A 34 of IPC and
all right, why should
4 of DP Act my lord. In the last occasion your lordship had this matter. On hearing your lordship was pleased to issue notice on the question of that the parents of the opposite party number 2, my parents of my wife are stumbling block on the way of my happy, peaceful and blissful life. On this question, your lordship was pleased to notice.
Very yes. Yeah.
Well, first of all, my friend is challenging the order of cognizance at the very limited stage when my instruction is that trial has commenced. Once trial commenced, then we participated in the cross-examination together.
No, if the wife and husband are happy with them, why are you standing in their way?
Coming. Second thing is that he is already a married person having 2 children. There is no question.
Even if the wife is happy, if the wife is happy with him.
No, I am not staying with him. I am staying in my parents' house, and he is staying with another lady and having 2 children.
No.
56
Urgent.
Short issue arises in these matters. Short issue arises in these matters, but it's a question of the rules that are framed in relation to transportation of cattle. Now I'll put in Lord. In this, if seizure takes place,
yes.
Lord, I must tell your lordship, we are a trust
Registered.
registered.
Yes.
If I may, Lord, we are a trust duly registered since 2002. We have a certificate of recognition by the Animal Welfare Board of India, the statutory body, and we have about 44 gaushalas accommodating 70,000 cattle and various other animals, about 500 odd, which is 8 to 20.
You are referring to the first item?
Yes,
in the
Lord.
list?
58.
First item in the list?
Yes, Lord, this is Dhyan Foundation, criminal MC 5310. I'm told it's the first item.
Yes. I'm in that. Yes. Okay.
Now, Lord, this is a trust certificate of recognition given by AWBI, and we have certain awards, but I don't want to trouble your lordship. But the awards are A4 at 27, which is Jeevan Jeev Dayal Award, and A3 at 26, a letter by the Border Security Force, because we rehabilitated cattle, which they've also discovered. They found.
Yeah.
This transaction arises from an FIR of 6 July 2023, where an FIR number 164 of 2023 gets registered under 11(1) ENF of the Prevention of Cruelty to Animals Act. Was 9 cattle. On a tip-off, they found that 9 cattle were tied and dumped in one vehicle. It's a Maharashtra registration vehicle. No food, no water, and there was no license, no relevant documents regarding the cattle. In this context, the cattle were, in terms of the rules, handed over to us by the learned magistrate, and the magistrate passes an order. He by the police. Sorry, by the police. Police give them to us on Zimanama in terms of the rules. The gentleman, respondent, goes to the private respondent goes to the magistrate, and an order comes to be passed rejecting his prayer on 2 grounds. 1, ownership is suspicious, and B, there's a non-compliance of the and he's in breach of the rules. And when you're in breach of the rules, the punishment at the end can also be that you're not deprived of the ownership of the cattle as well. So that's the principle of law that has been brought in by these 2017 rules.
Right.
He goes to the Sessions Court. Now, Sessions Court does one very interesting thing. Claims to be the registered owner, claims to be the bona fide purchaser, and says, look, give me this cattle, and ownership was not properly verified according to him. Now, he shows certain purchase receipts, 3rd July 2023, which is A7, and certain certificates. And based on those certificates, which is according to us a forged certificate, he gets possession of the cattle. Now, this is where the position stands. We get to know about this. We write to the authorities concerned from whom the certificate issued, which is the Assistant Director Animal Husbandry, and that's Annexure A11. And we discovered that that certificate is a fabricated certificate. So there are 3 levels of infringement, and I'll make good that submission. First, see that certificate for a moment, Lord.
Page 51.
Yes, not 51. Now, my Lord, we see this is the certificate which he relies upon. This is to certify that K. Narendra Prasad, son of so-and-so, Ankampalam, East Godavari District, AP, doing Desi breed, agricultural breeding and farming purpose of Desi breed. As part of this activity, they exchanged with 5 pieces milking cow, 4 pieces breeding cow with 2 female calf from Vijayawada to Dhankuri, Hooghly District are transported from Andhra Pradesh under Rule 96 of the Transportation of Animal Rules. Now, there are actually the rules are now changed. There are 2017 rules also which have come into play.
That is care and maintenance.
Care and maintenance rule. This is
Transport of
not.
animal.
This is on transportation, but the care and maintenance rules have to be read together. Now the rules in effect.
The cattle have to be transported under the care and what is that rule?
Cattle have to be they're transported under the transported rules, but the requirements of the care and maintenance rules have to be met.
Okay.
2017.
So 70, these are the 78 rules, and in the 78 rules, Lord, there is Rule 56 says what are the precautions to be taken. I'm not going to get into that, but it's most important thing is you can't have more than 6 cattle as per Rule 56C in a vehicle. 56C. He had 9.
Yes.
This certificate, because we got to know only at the stage of after the revision was decided, we made inquiries and we sent a communication. And at page 52, on 17th of October, a certificate issued, which comes to us, which discloses, and please read, second para, after the sentence, NGO urged to check the validity of documents through email dated 11th October 23. Upon inquiry, it is observed that signatures made in the certificates by Veterinary Assistant Surgeon Mangalagiri and Assistant Director Livestock Development are forged and proved to be fake, which is a serious violation of policies and procedures. Aforesaid officials have not issued the certificate and the matter is to be viewed seriously. So that's the first part. The second part, Lord, which I want your Lordship to consider is this. Please see the magistrate's order for a moment. The order is at Annexure A6, page 38, relevant page 39. Second paragraph.
Page 39.
Yes.
Yes.
Heard the learned from both sides, peruse the case record, CT case number so-and-so. From the seizure list, it is forthcoming that 4 numbers of ox and 5 numbers of cow.
1 minute. Let me reach there. 39. Okay, I got it.
39
Yes.
second para, my lord.
Yes. 39. Yes.
Says her, whatever heard from both sides, peruse the original case record, CT case number so-and-so. From the seizure list, it is forthcoming that 4 numbers of ox and 5 numbers of cow have been seized from vehicle number so-and-so, and to prove the ownership of the petitioner, we filed original money receipt bearing number so-and-so and bearing number so-and-so, dated so-and-so. The documents, no documents apart from this, neither documents or valid license has been filed by the petitioner. The receipt filed by the petitioner is in Telugu, which the court was unable to understand. Hence, the interpreter was called for translation. The HC so-and-so, Indira Nagar so-and-so. Thereafter, with the help of the interpreter, the receipt of Telugu language was transcribed to English language, which is filed on the with an affidavit attached to the case record. On detailed perusal, it is said the receipt is under Vyabasaya Market Committee receipt of Pantamaluru, Tankipadu Krishna Zilla in the name of K. Narendrapa, G. Mali Babu and Ramesh Babu, and Rotap village. It pertains to the market fees receipt of purchase of 5 cows and 4 bulls at 1% rate. However, the receipt does not clearly state the sale and purchase of the said cow and bullocks. After perusal of the case record and connected papers, certain facts can be brought. Firstly, the money receipt is in the language which Telugu has been interpreted. It doesn't identify, clearly denote or show that the petitioner is the registered owner of the cow and bullocks. The receipt is merely a market committee tax receipt in favor of the purchaser of the cattle. Secondly, receipt is the name of 3 people, K. Narendra Prasad, Mali Babu and Ramesh Babu. Thirdly, and this is most important, no description or identification marks of cattle, color, type, tag number is mentioned anywhere in the receipt of the petition. Since there is no other document conclusively justifying the purchase of cows and bulls in the name of the present petitioner, Narendra Prasad, the court is unable to ascertain as to the ownership of cattle. Thus, the petition stands rejected as devoid of merits. I must point one thing out to your lordship, that this order will become the subject matter of a challenge by him before the Sessions Court. Now, the Sessions Court looks into the matter, Lord, and I'll just make good that submission. Just a minute. A5, Lord.
Which is that order? Sessions?
Yes, Lord. But I must point out, Lord, the petition will be at page number 28, I believe. Just a minute. The revision. Yes. It's at 28. 28. Lord. In the revision, kindly note, all he says at page 29, para 3 is impugned order is improper, illegal, and against the provision process law, which is to be enforced by this court for the ends of justice to prevent the miscarriage. Or he is the registered owner, and if the cattle are kept at Gaushala, petitioner will meet irreparable loss. Now, this is what he says, etc. Nothing more, nothing less. No other justification in terms of any relies on that certificate, which I have told your lordship, which is found to be forged, and that certificate is the basis by which the court has acted, which we showed you at page 51. Now, the Sessions Court note at page 31 is where the
Come to
order.
straight away come to page 35.
Yes, but I was coming to that. Para 5, considering the above submissions and the rival submissions of both parties, and I'm going through the documents available in NCR, I find that the petitioner is the registered owner of the seized cattle. Undisputedly, SI seized the cattle on the allegation of commission offence under so-and-so. It reveals that trial of the said CT case is not commenced. Learned court below is called for report from the concerned PS as to the purpose of requirement for purpose of investigation, where the IU has submitted alleged seized cattle in question is not required for further investigation. In the backdrop of the above facts, recourse may be taken to ruling of our own High Court, given in the case of Gau Gyan Foundation so-and-so versus State of Orissa and other reported so-and-so. In that Rudrasham Gaushala case, Honorable Court referred some principal rulings that relied by revisionists. In the just mentioned Rudrasham Sharm Gaushala case, the Honorable Court held there is no absolute ban for the accused owner to taking custody during pendency of litigation. So being alive to the position, this court is of the opinion that revision petition is to be allowed as he is the bona fide purchaser of cattle entitled to its possession. In view of the above facts, I am inclined to release interim custody of the cattle line numbers in favor of the petitioner by depositing all dues to the secretary so-and-so. The entire reasoning is at page 36, which your lordship has seen. There is nothing else said. Now I pointed out 3 people. Firstly,
What about the other connected matters? The facts must be different in all the cases.
Slightly different, bro.
Again, in all the cases, the dispute is regarding the ownership.
Yes.
All the cases. Now the issue boils down to the fact that on the facts for each individual case where the ownership is disputed, whether the interim custody given to the accused persons is sustainable under law. That's the long and short of it. Okay.
Yes, but and for this purpose, not kindly look at the 2017 rules. They are called the Prevention of Cruelty to Animal Care and Maintenance of Case Property Rules 2017. Now, here, if lordship is kind enough to see sub-rule 3, where an animal has been seized under the provision of the act of the rules made thereunder.
1 minute. The rule, yes.
Rule 17.
Rule 17. Yes.
Where an animal has been seized under the provisions of this act, or rules made thereunder, the authority seizing the animal shall ensure health inspection, identification and marking such animal through the jurisdictional veterinary officer deployed at so-and-so, and marking may be done by ear tagging or by chipping or any less irksome advanced technology, but marking by hot branding, cold branding and other injurious marking shall be put. Now, B is important. The magistrate may direct the animal to be housed in an infirmary, pinjara pole, SPCA, animal welfare organization, or Gaushala during the pendency of the litigation. Now, this is not the power that vests, and that power has been exercised already, and there is no reason to say why the power is wrongly exercised. Rule 4 says how cost, etc. has to be determined. Rule 5 talks about the bond that I have to give to ensure that the animals are kept properly and they are looked after. So there's the owner's cost on me. Now, please come to rule number 8.
Rule 8.
Yes, ma'am. If the accused is convicted or pleads guilty, the magistrate shall deprive him of the ownership of the animal and forfeit the seized animal to the infirmary, pinjara pole, SPCA, animal welfare organization, or Gaushala already having proper custody for proper adoption of the other disposition. If the accused is not found guilty of the charges, seized animal shall be returned to the accused owner of the animal, and the unused portion of any of the amount executed, of any bond amount executed, shall be returned to the person who executed the bond. So, the manner in which these rules have been brought in and the way they are framed is twofold. One, that in the event of conviction, they will be retained by us, and in the meanwhile also, for their care and keeping, they ought to be orderly given to a infirmary, Gaushala, etc. And this is our activity. Now, I must also point out, the rules are also clear, not that if the vehicle is involved in offense, they shall direct the vehicle to be held as security. It is nobody's case that there were not 9 vehicles in that, nine cattle in that vehicle. That's their case. If so, there is a clear breach of the rules. There is no issue there, not. They will have to make out because it's not that case. They are admitting ownership. They are saying this is the seizure that is done. So, and secondly, on the ownership, though they are alleged to be 3 owners, the document that they rely upon is a questionable document.
Because it is a false document.
Indeed, that's a short issue to see. Now, not yes, not to deal with the judgment of the Honorable Coordinate Bench, if I may just deal with it, not. But the judgment of the Honorable Coordinate Bench 2023 SCC Online Odisha 294 really looks into the interpretation of the rules.
Take it up. 1 minute. Take it. Yes. Which one?
But relied upon judgment 2023 SCC Online Odisha 294.
And your compilation, which one?
No, Lord, this is separate. Mr. Sahu will hand it over. Lord, this is the judgment relied upon by the learned section.
Yes. Yes.
Lord, if my Lord is kind enough just to see that. Lord, this is, since my Lord puts it to me, I must point out, this is referred to by the learned judge at page number 36. Now, before, Lord, just come back to the paper book for a moment before you go a little further.
Yes, go foundation.
Yes, but I just want your Lordship to see one more thing. But one more thing, keep a note, not in para 4 of the revisional order, there is reference. My Lord knows that the criminal code in terms of 362 will be barred, Lord. 362, there will be a bar. I can't go back to that. The court can't recall its own order. Though in 482, my Lord may do it, recall an order because the power is much more vast.
Yeah. Yes.
But put it very simply, the issue really was this, and I'll just bring your Lordship to para 11. It's a rather long para. If we have the same copy, it'll begin as Lord, para 11 will begin, and
why
the court
I will set aside this order and relegate you to the magistrate court to consider the veracity of that document, ownership document, and on that basis, the application may be decided afresh.
My Lord, if I may just point out very simply, today, my Lord, the only thing is my case is it's a case of cruelty, and there was no justification in law for the learned session judge to interfere with the magistrate's exercise of discretion. I can understand if the magistrate had erroneously exercised jurisdiction, because revisional jurisdiction under 397, there has to be illegality, irregularity, or some fundamental error. Something has to exist. The learned session judge doesn't look at that. He just says, you're the owner, so you should get it. There is no reasoning as to what is the impropriety, illegality, or irregularity in the order of the learned session magistrate.
But your case is centered on these documented page 51.
My Lord, that's a supplementary argument. I must say this. Lord, that's a supplementary argument. But I'm saying, Lord, today if the magistrate exercised jurisdiction in a certain manner, was there occasion for the learned session judge to say that had not?
Right. That's a different argument.
That's a principal argument. Forgery is a supplementary argument that it's a false document, because my case is that even if it was a case of forgery, let us assume for a moment it's a valid certificate. I accept that. And it's not a forgery, which I've later found out. Even then, was it a case for the learned session judge to interfere with jurisdiction?
Right.
That's a real argument. And if my Lord considers not all
that argument may be suffice for all the matters.
Indeed, Lord. And Lord, all the court. Yeah, I'm sorry. Yes, Lord.
Yes. But insofar as that forgery issue is concerned, it may not be right insofar as the other connected matters are concerned.
Would not be. Lord, it's in this case specific. It's specific to this case.
Now,
Lord, the only thing this judgment does in para 11, and I won't trouble your Lordship, all it says is there is no reason, there is no ouster of the right of the owner to get the property, the cattle. There's no ouster. The question is that he or she can get the ownership, but should he or she get it? And that's where the discretional comes in, where the magistrate exercise powers in terms of the rules. That's a short issue. I'm not on judgments. I'm sorry, my learned friends. I must tell you what happens is we end up doing some of these matters and we kind of bulking up. Kindly just consider not just one short order of the Honorable Supreme Court.
Compilation.
Just a minute. Wo de do, no,
In the compilation, it is there.
Yes, what?
Sir, Raghuram, sir. The prima facie case made out cannot be given.
But just see one judgment plot, which is Raghuram Sharma. Just a moment.
Yes, I got it, Raghuram Sharma. Page
Yes,
10.
20, Lord. And if my Lord is just kind enough to see in Raghuram Sharma, Lord, paras 10 to 13. Lord, kindly note, para 10 records the arguments in Rule 56 of how cattle are to be taken.
Raghuram para 10, huh? 1 minute. I just
Para 10.
note it.
उसमें केवल वो है सर, केवल रूल को कंसीडर करना ही जी becomes person.
Yes.
I'm not
Para
saying
10, yes.
para 10. Ms. Mathur, learned senior counsel, invited our attention to Rule 56, and I am relying not on Rule 56C. No goods vehicle shall carry more than 6 cattle. Then para 11. Thus, a container or a vehicle should not have carried more than 6 cattle, but as the facts indicate, the number of animals which were transported was 37. Governing norms and principles were thus violated. It does not appear to be a single or solitary incident. In subsequent FIRs against permissible norm, number of animals were being transported was 47. The fact that this had an adverse effect on the health of cattle is clear in as much as in the present case, one buffalo died while being transported and the subsequent 6 animals lost their lives. We are not arriving at any conclusions as regard the basic facts and the allegations leveled against the accused, but if you go by the allegations of the FIR, the accused were prima facie guilty of causing cruelty to the animals. In such a case, interim custody of the animals ought not to be handed over to the accused. If the accused are finally found to be not guilty, then the issue of custody of the animals will logically be dealt with in accordance with the concerned rules or regulations. But at this stage, accused are definitely not entitled to interim custody. We therefore set aside the appeal order passed by the High Court and direct is under. And Lord, they are subject to the being satisfied about the profile of the present appellants as well as ensuring the identity of cattle. Custody be allowed to be retained by the appellants. And the appellants not were these people, Raghuram Sharma, etc. And they said you can't give it to the persons who are.
Raghuram Sharma Gosala.
It's a Gaushala manager. Lord.
Judgment. Gujarat High Court.
Rule 56 was relied.
Yes, Lord. And ours is a case of Rule 56 violation. I can add more judgments and bulk it up, but I don't see the purpose of disturbing your lordship with not unnecessarily more judgments. But
sustained.
And not similarly, there is a judgment at Meher Banu, which is a Guwahati High Court judgment.
Meher Banu.
Meher Banu, Lord, Gujarat, Guwahati High Court judgment, where
yes,
my Lord see
which paragraph?
31, only asserting the ownership by person one cannot sort for zimma of the animals that have been transported in blatant violation of the Act. In terms of 11.2, an owner should be deemed to have committed an offence if he is failed to exercise reasonable care and supervision with a view to prevention of the offence. Even going by the principles in the principle supra relied by petitioner, it is seen that petitioner cannot avail the same benefit as the authorities observe that owner will have a claim over the custody of animals if the animals are not liable to be seized and condition of the animals at the time of inspection is well maintained. Whereas in the present case, apart from claiming ownership, it is not disclosed that proper care was taken at the time of transportation as mandated under the law and rules. Large number of cattle were carried without required documents. From the materials available on record, it is evident there is a violation of Rule 56C, nor the required medical certificate is being furnished from the qualified veterinary surgeon as per Rule 47A of the Transport of Animal Rules. As per 47B, such certificate is required to be issued by the doctor at the loading point, in the present case West Bengal, whereas it was issued by a retired veterinary doctor of Assam at the end point. Though the revisioner petitioner was allowed to restart its cattle transportation business by Animal Husbandry Department for agricultural purpose. It was directed that the same may be carried out under strict adherence to the animals rules, and petitioner has totally failed to adhere to the aforesaid rules and act. Then what section 3 is duties cast out in para 34. Para 35 talks about 29. And para 36 says the animals have been carried in breach of the rules. And in this basis, they said that there's a rejection of the Zimmernama. And not the next judgment is page is
granted was
the
rejected.
Supreme Court.
Yes.
Yes, Lord. And Supreme Court, Lord, has upheld this decision in the next order, which is 26 September 2022.
Yes.
And para 5, the court said, question whether the petitioner Meher Banu Begum is entitled to custody would be decided upon the decision in the trial. So, not normal rule that is being applied by the court says these matters, keeping in view that there is an apparent breach of the law prima facie, because the law is very clear. It's an absolute liability case, no intent case. Not therefore, the custody should be kept with the Pinjra pole or the Gaushala.
Pole or the
Gaushala, as in my case.
Gaushala.
Yes, that's all I had to say. I'm deeply
Yes, who is appearing?
Mr. Bharat.
Sir, Acharya is appearing
State,
for the...
state doesn't, state.
We have no role. We have no role.
You support.
Yes, supporting.
And
for number 2, Mr. Acharya is appearing through VC money.
Yes, Mr. Acharya.
I am appearing for the OP number 3, Your Lordship.
Yes. Tell me, what is your point? What do you want to say?
Only point, Your Lordship. The order passed by the Honorable Session Judge Baripada is just and proper. It's because I am submitting, Your Lordship. After verifying all the connecting documents, the Honorable Session Judge Baripada passed this order. And my respect to submission, Your Lordship, the Dhyan Foundation Gosala has no local standing at all to file this case. On which capacity, Your Lordship, he has filed this case? So, sir, my Lordship, my lawyer friend supplies one thing, Your Lordship, that after passing the order of Lord JMFC Baripada, he has received 1,60,000 for the care and maintenance of the cattle. And my respectful submission, Your Lordship, suppose the fact is true, what prevented him to appear before the JMFC Baripada, so also the Honorable Session Judge Baripada? What prevented him? Only lingering this matter, he has filed this case against me. I am the bona fide owner and I am a farmer. Only for the purpose of farming, I have purchased this cattle. That's
You want to file any written submission?
Yes, my Lordship.
Do you want to file any written submission?
Good. I can give a one-page note, not at the most. One page.
I am reserving the judgment and you file your respective written note.
We'll do that.
My Lord, so for the rest matter is concerned.
Mr. Maharaj, you have given it.
No, we don't have anything. Only that is, we have already given them chance. But we have given them Jima. So that is their duty to assist. And we are here to assist your Lordship and with the CD.
Now, if you want to give any...
No, nothing is there.
Lordship, learned senior advocate Luthra sir appearing in CRMC number 5310 of 2023 only, my Lord. And rest matters are, my Lord, that is a different one. And that notice is not sufficient, my Lord. So your Lordship may kindly reserve this order for 5310 of 2023.
Yes.
In all other matter, notice is not sufficient. Mr. Acharya, you are appearing the first matter or the other matter also?
First matter.
By the way, Mr. Acharya, you are appearing in the personal capacity or as a counsel for the party?
On behalf of appeal number 3.
But I don't think you are in rope.
I think the band is not showing.
You don't have any band. And you are appearing in High
Are you
Court.
in rope? You are appearing in the High Court.
It's not.
Sorry, Your Lordship.
Sorry.
Sorry will not do.
Sorry.
You should be careful.
Go bad message to the other already in VC.
If you are appearing in the High Court, the liberty of appearing in the VC doesn't mean that you will not wear the rope also. What is this?
Sorry, Your Lordship.
Shall I impose little cost on you
No, sir.
so that you will be careful in the future? Please don't do that, okay? You are not appearing in any other matter?
Lord, I'm only in this one matter.
Okay. What to do then? What to do,
Your Lordship
Mrs.
may
How?
kindly direct the registry to verify. Your Lordship may kindly direct the registry to verify all the case record, whether the notice is served or
Service
not.
question, tell me. Insofar as the first matter is concerned, judgment reserved.
Yes.
That's fine.
5310 is concerned, sir.
Judgment
Keep you
reserved.
like-
I was thinking that we can dispose of many matters. That's the reason I was eagerly hearing. Anyway.
Luthra sir will appear in another day for another matter.
But whenever, but I think once your Lordship
Okay,
judgment comes.
that will allude to the benefit of the deciding other matters.
Yes.
I'm grateful, Lord.
Thank you.
Keep you obliged. Grateful, my Lord.
Okay, thank you. Oh, see the service position and check it up, then we will let them. Okay.
29.
Last occasion में in this matter both the parties appear and matter will be settled manner. My lord direction for receive the amount. Last occasion payment receive she already received as per instruction man.
More mother say instruction also I have not received any written instruction, so I am not sure that whether he has received or not. But I have discussed with the IO and also IIC. So, initially the complainant disputed that I will not accept the money. If I will accept, I will not disburse.
No, the IO has kept all the money.
Yeah, yes. IO said you take the money and distribute among the members. He said I will take only I will take all the money. I will not distribute the money.
That is the reason he came to the court. The other people are not there. He has only 30,000 rupees.
I discussed all the members. All the members were present and over the phone, and except that man, and he is not cooperating.
So you want to take the entire amount which belongs to the members?
At the 19 member at the presence of 19 member 19 टा member को आगे रे payment दिले
ଆପଣଙ୍କର ଯେତିକି ପଇସା ସେତିକି ନେବେ ନା
ହଁ ତାପରେ ସେ distribute କରିକି ମାଲା
ଯଦି ନଦବ ମତେ ତାହେଲେ ମୁଁ କେସ୍ କରିବି ଆପଣଙ୍କ ନାଁରେ ମୁଁ ଏସପି କି ଜଣେଇବି ହି ଇଜ ଓପନ ଚିଟିଂ ଗିଭିଂ ଥ୍ରେଟନ୍ ମୁଁ ସେଇଥିପାଇଁ କହୁଥିଲି ସେ ଇନୋସେନ୍ସ ନା ଦେଖାଉଛି ସେ ବହୁତ ଡେଞ୍ଜରସ୍ ପର୍ସନ
this is not allowed. You want to appropriate the money of the all 19
all members, you know, sir, but they are all laborers.
Laborers,
collection money ଟା ତମେ ଏକା
already ଦେଇ ଦେଇଛନ୍ତି ସମସ୍ତଙ୍କ ଆଗରେ ଆଜ୍ଞା ସେଟା ସେ ଭାଗ କରିବେ ସେ 19 ଜଣ
ଭାଗ କରିବେ କି ନ କରିବେ କାଲି ଆଉ ଜଣେ କି ଆସି କହିବେ ଆମର ତ ପଇସା ମିଳିନି କହିଲେ
କାରଣ ମଣ୍ଡେ ଆସୁନ ଇନଷ୍ଟ୍ରକ୍ସନ
ତାକୁ ଦିଆ କରିକି ଆସନ୍ତୁ
ନାଇଁ ଦିଆ ସରିଛି ସେଟା ସେ ଆୟୋ
ଆପଣ ସବୁ ଯାକ ମେମ୍ବର କୁ ଡାକି ଆଣନ୍ତୁ ସେ କହିଛନ୍ତି କୋର୍ଟରେ ଡାଇରେକ୍ଟ
କିଏ
କାଲି ସକାଳେ ଆଉ ଜଣେ କମ୍ପ୍ଲେନ୍ କରିଦବ ଆମେ
ହଇରାଣ ସିଗ୍ନେଚର କରିକି ଦେଇ ଦେଇଛନ୍ତି ସମସ୍ତେ ଲେଖିକି ମାନେ ଆମେ ରିସିଭ୍ କଲୁ ବୋଲି ସେ
ସମସ୍ତଙ୍କୁ କୁହନ୍ତୁ
ସେ ଆୟୋ ନିଜେ ନେଇଛନ୍ତି ଆଜ ପର ଇନଷ୍ଟ୍ରକ୍ସନ 19 ଜଣ ସେ ପଠେଇ ନାହାନ୍ତି ନହେଲେ ଲେଖିକି ଦେଇଛନ୍ତି 19 ଜଣ ଯାକ ସିଗ୍ନେଚର କରିକି ଦେଇଛନ୍ତି ପଇସା ରିସିଭ୍ କଲୁ
ସେମାନେ ମୁଣ୍ଡ ଖରାପ ହେଲେ ତାଙ୍କର ମୁଁ ତ ମୁଣ୍ଡ ଖରାପ ହେଲେ ତାଙ୍କର କଣ ମୁଁ ନିଜେ କଥା ହଉଛି ସମସ୍ତ ସାଙ୍ଗରେ ସିଏ ଆସୁନି ଫୋନକୁ ବାବୁ ଆସୁନା ମୋ ବା କୋର୍ଟ କହିଲେ ଯେ ଆପଣ ଟଙ୍କା ନେଇ ସମସ୍ତ ବାଣ୍ଟିବେ ସେ ବିଲକୁଲ ଆସୁନାହାନ୍ତି
let him be present in the court
ଏତେ ବଦମାସିଆ କାମ କରୁଛନ୍ତି ସେ
let the petitioner appear in the court in the next date appearing and the IIC na IIC Daswantpur IIC Daswantpur police station along with the IO in the present case may also appear in the court through VC. We will interact and see.
Either or, my lord. either VC or in
VC or-
ନାଇଁ ସେ ଆସନ୍ତୁ ସେ
ଆସ person-
ବହୁତ ଅସୁବିଧା କରୁଛନ୍ତି।
ଦଶମନ୍ତପୁର କେତେ ଦୂର ଅଛି?
କୋରାପୁଟ କୋରାପୁଟ ଦଶ
କୋରାପୁଟ କୋରାପୁଟ ଦଶମନ୍ତପୁର
ମାଇଲ।
ଆଉ ବହୁତ ଦୂର।
BC ଥାଉଛି ସେ।
ବିଶେଷ
ବହୁତ ବର୍ଷ
ଗଲେ ଆସିବାକୁ ଯିବାକୁ 2 ଦିନ ଲାଗେ। 30,000 ଟଙ୍କା ଚକ୍କରରେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ has to spend more than
A free copy will also be, I will intimate
free copy Tuesday.
Tuesday ମାଇଲ।
ମତେ ଟିକେ ଦେଇ free copy ଟା ମୁଁ intimate କରିବି।
61.
My lord, your lordship, there is some problem, so that matter will next week any day, my lord.
Urgent. Yes. Tuesday. This is the best prayer you made. You made everybody relief.
But today also, I learn one thing from your lordship. Why you are mentioning in the prayer person any other orders or direction may be passed. For that in your lordship, quash the FIR which is annexed the that case, my lord.
Naturally. See, we have to do substantive justice.
My lord.
We need not go into small,
My lord,
what
my
you
lord.
call procedure
For
and
that
all,
is in my lord.
create
No,
problem for the.
Although you are mentioning in the prayer person any orders, direction may be.
Because that is the reason 482 is meant.
My
You have to
lord.
do substantive justice.
Oblige.
The only difficulty is neither the petition are properly drafted,
Yes,
nor
that is
carefully done.
whole
So
difficulty.
then there is the whole difficulty. That's what to do.
The proper drafting ନାହିଁ କିଛି ନାହିଁ ଫୋପାଡ଼ି ଦେଲେ ସେମିତି।
No, the obvious ହେଇଗଲାଣି।
No, my lord.
You saw that.
Yes.
311.
Unless until I go through the charge sheet, I could not able to find out who
But
are
the problem, another
who are
problem is
PW3.
if you keep any judgment reserve, then you see the file, you are thoroughly confused.
Yes.
Something happens in the court, you find out in the record nothing is there.
Nothing is there. Yes.
Then coordinating is very difficult.
My senior also now Manas Chandra was arguing without looking the record.
Yes.
I have seen, I have looked, you have not read the record.
Oblige.
Oblige.
ବାରଟାକୁ ଡିଗ୍ରେଡେସନ କରୁଛନ୍ତି ସମସ୍ତେ ଲେଖା ଠିକ ହଉନି ତାହେଲେ ବାରଟା ଆମ ଡିଗ୍ରେଡେସନ ହଉଛି।